ಒಂದ್ ನಿಮಿಷ ಫೋನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಮಾತಾಡ್ತಾರೆ.
ಓಕೆ ಓಕೆ ಓಕೆ. ಪೋರ್ಟಲ್ ಇಲ್ಲಾಂದ್ರೆ ಪ್ಯಾಂಟ್ ಇದ್ರ ಮೇಲೆ ಮತ್ತೊಂದು ತೊಂದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಂದ್ರಾ? Court officer. ಭಟ್ರೆ ಹೇಗಿದ್ದೀರಿ? ಆರೋಗ್ಯ ಹೇಗಿದೆ?
ಚೆನ್ನಾಗಿದೆ ಸರ್.
ಓಕೆ ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು, ಟೇಕ್ ಕೇರ್.
5-year wait orders. Two 2011. Let us see. Wait, Madras called it. Serial number 5 tane. Please wait. When the matter is called, this 2015 matter, 8-year-old. Let us see, let us see. Please mention when it reaches. Please mention it when it reaches. Reach ada mention man. Same, mention it when it reaches. 14. Memo is filed requesting that the petition be dismissed as withdrawn. According to the said memo, the petition is dismissed as withdrawn. Please wait. You don't have to be here. I'll mention it. Ask somebody else to mention it on your behalf. As requested, the petition is dismissed as withdrawn. No, that will be wrong because they are not before me. The appellant is not before me. If I were to issue a direction, you make a mention that it will be posted next week. The court has said that they disposed of. Let us see what they do. Stated that they are notified in the course of this time. Hello, ಆಗಿದೆಯಲ್ಲ ಫಸ್ಟ್ ಏಡ್ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. What is the matter about? Bill is Thompson. By which time? Cost need to be amended. We need a substitute. Whom do you want to substitute? Is represented. Is permitted to be substituted. IA1/23 is according to the law. What is IA2/23? What is IA2? The application filed under 151 for amendment of the cost schedule is also allowed. IA3 to be considered along with the main matter. What is the matter about? What is the matter about? Who appears for the respondent? Ready na ನೀವು? Who's R3? Is no more. Huh? How is related to the petitioner? How is related to the petitioner? Who are the LRs of the third respondent? Notice ಹೋಗಿಲ್ವಾ? She notice on IA3 and 4 of 2004. One data. What is the main matter about? Lecture. Page number? Yes, what is wrong with this?
What had happened is, number 6 branches are one of the branch, 5 branches is the branch was second from the there is a specific part of private interest in fact. Page number 98.
19.
The inquiry is being proceeded again. How much inquiry. Subject matter. Divisional authority reminded against which conduct and the branch budget. Pursuant to the remind matter, the district commissioner once again said the allegations are. Was a revision before the divisional authority reminded so the order and connection came under very now when this is the first part of it. And this was the case for what they did was what the driver was. They find a honorable apparently that order connection came.
How are they related to one of the branches?
Yes, no one doesn't have service freedom that service. Raghunandan is the nine. So they find a they have find a this one. So one was building together. Both of them. We order connection. That was for me. Deputy Commissioner once again said, no, I have to really pass here. And then for the second time,
Yes.
it is 130 order. That is Deputy Commissioner for the second time. So I have already passed an order on 78. Question number
Yes.
so there are two orders which are sharing every respondent. One is the original order at annexure.
ಅವರು ಏನು ಹೇಳಿದ್ರು ಗೊತ್ತಾ ಮ್ಯಾಟರ್ ಮೆನ್ಷನ್ ಅಟ್ ದ ಟೈಮ್ ಓಕೆ ಯಾಕಂದ್ರೆ ಮತ್ತೆ ನಾನು PG ಹಾಕಿದ್ದೇನೆ
For a party to this annexure on
Section P is passed by the revision measure. That is the improvement. So on the count of non-resident.
yes.
ಅಂದ್ರೆ ನೋಡಿ ಇನ್ನೂ ಉಪಯೋಗಿಸ್ಕೊಂಡು
No, they were parties to the order in which this Kambadhan Samaya was asked not to become the archer, correct? Answer the question. They were parties to the order. The first order of this court, in which Kambadhan Samaya was asked not to work as archer. To that order, they were parties. So if they were parties, how can you bypass them and secure another order? Not four. Unless that order of the deputy commissioner, unless the deputy commissioner decides on your eligibility to be the archer, how can there be an order? What was the allegation against your father? Both of you were doing archership along with your father, correct?
These are the petitioners of the second time and these are petitioners applied in the villages of the Karnataka. This is the correct complaint only given by these tracts. No complaint. Measure they are given any complaint. Please father of the respective. Here there is a two complaint. One is complaint against the patient. But they have made manner of that to the commission. These 3 months. They have conducted and this for the nursing year is 94 years, claiming the non-land.
I will set aside this order, asking them to be implemented and the matter be heard again.
Here were my permission. Here section 9.
If annexure P is given effect to, it has a direct effect on them.
Only 1 year.
If you are not entitled to do the archership, their term of archership will get increased. Yes or no?
Only 1 year only our role is only 1 year. You are not incident in the year 2010. Created on year 2010. Till today, their inquiries proceeding under they are not proper inquiry.
The connected matters in relation to that inquiry. Annexure P is before whom? That's a different authority.
So far as they have filed the application, we have the eligibility qualification and we kindly transfer our application from father.
Let that be redecided after you hear them. They were parties in the first order on the basis of which an inquiry was conducted against you. So let them be heard in the matter and let him pass a fresh order.
Yes, my contention is because Samadan has made no more. Year 2000.
You can make this argument there in his presence. Let him also be heard in the matter. Your father's archership was brought to an end because of his complaint. So if you have to revive it, why don't you hear him and then pass an order? Second matter ಏನು prayer.
Including the pregnancy of the patient again all these.
Annexure Y. What is annexure Y? But she has a point in the sense if the allegation is against at Kambada Narasimhaya and if he is no more. Next year.
Another party even to get it. Might election facing. To make it against understanding also.
Acharya is the son of Kambada Narasimha.
The access of temple other than the has collected large amount of
What was annexure Y in the writ petition that they have filed? What was annexure Y? Why was it passed? Pursuant to the order of this court. So the main inquiry is still pending to the deputy commissioner. I will direct the deputy commissioner to decide this inquiry and thereafter set aside this order, and this order will be passed after subject to the result of the deputy commissioner. You have not been doing architecture for 13 years now. That is yet to be approved, isn't it? Not. The dispute between the 6 batches of archakas who perform pujas in turn year by year at Lakshmi Narasimha temple, which is situated at Kamasandra village of Dasanpura, Hubli, Bangalore Taluk. An order was passed by this court in WP 31732 by 2011, remitting the matter to the deputy commissioner for a fresh disposal in accordance with law. This court, there are 5 other. 19. WP 28745. Order was passed by this court in WP 28745 by 2010, stating that as the inquiry was being proceeded against Kambada Narasimhaya, this court refused to entertain the writ petition. This court directed the Deputy Commissioner to hold an inquiry against Kambada Narasimhaya and thereafter take appropriate steps. And until such time, Kambada Narasimhaya was held not entitled to perform puja, the interest of the temple, as well as the devotees at large. It is not in dispute that this inquiry is yet to be completed and is still pending consideration before the Deputy Commissioner. In the meanwhile, it appears that the petitioner had sought for petitioner Salva, the son and grandson. The sons of Kambada Narasimhaya, that is petitioners 5 to 11, respondents 5 to 11, had sought to be appointed as the archaks and be permitted to perform puja according to their turn. And since the same was not considered, a writ petition was filed before this court seeking for a mandamus. And this court directed the Deputy Commissioner to consider the same and pass appropriate orders. In compliance with the said order, the Deputy Commissioner, the Commissioner, Deputy Commissioner passed an order on 25th of June 2019, stating that the petitioners cannot be appointed as archaks in view of the fact that the inquiry against them, against Kambada Narasimhaya, their father, was still pending consideration. This order was challenged by way of revision before the Commissioner, and the Commissioner, by the impugned order, has directed that the inquiry be concluded. The inquiry that had been initiated against Kambada Narasimhaya be concluded within a period of 3 months. And thereafter, the right of respondents 5 to 11 to perform the puja be considered. He's already done that, isn't it? He's already done that. He said, can conclude the inquiry within 3 months. It is the grievance of the petitioners that they were not made parties in these proceedings. So the inquiry against Kambada Narasimhaya was initiated at their instance. It is therefore submitted that the order which has been passed behind their back cannot be sustained. WP 34094/2015 is preferred by the two sons, by the son of Kambada, one by K. Srirangacharya, son of Kambada Narasimhaya, and his son Raghunandan, challenging the order of the Deputy Commissioner, by which the Deputy Commissioner has refused to consider the request for being appointed as archak to perform the pujas at the aforementioned temple, on the ground that the inquiry against Kambada Narasimhaya was still pending consideration. These undisputed facts clearly establish that the complaint which had been lodged against Kambada Narasimhaya and his son Srirangacharya are yet to be adjudicated. The branch of Kambada Narasimhaya was not permitted to perform the archakship by virtue of an order of this court, which was passed in the presence of the petitioners. However, an order has now been passed by the commissioner directing that the inquiry be concluded, and at the same time, the claim of respondents 5 to 11, that is the sons of Kambadana Samaya, to be considered for performing of puja. Since the allegations against Kambadana Samaya and his son that they had misappropriated huge sums of money are still pending adjudication. The order passed by this court in WP 28745 by 2010 on 28th of September 2010 will have to be obeyed, since the same has also been confirmed in writ appeal number 3957 by 2010. Unless Kambadana Simhaya and his son are exonerated of all wrongdoing in the inquiry conducted by the inquiry to be concluded with the deputy commissioner, it is obvious that Kambadana Simhaya and his successors cannot perform the role of archaks. In this view of the matter, I am of the view that the impugn order passed by the commissioner, insofar as it relates to directing the consideration of the claim of Kambadana Simhaya's children perform archakships, cannot be sustained. To this extent, the said order is quashed. Since this order that I am passing now is in consonance with the order passed by this court in WP 28745 by 2010, and since the order passed by the deputy commissioner, which is impugned in WP 34094-95 by 2017, is in consonance with the order passed by this court already, I find no merit in this petition. The petition is therefore dismissed. As a consequence, it would be appropriate to direct the deputy commissioner to conclude the inquiry that had been initiated against Kambadana Simhaya and his son, as directed by the commissioner in the order dated 22/4/2021, within a period of how many months? 2010 ಇಂದ ಮಾಡ್ತಾನೆ ಇದ್ರೆ within a period of 3 months, on such consideration being made, and if Kambadana Simhaya and his son are exonerated, their claim for archakship shall be considered within a period of 1 month thereafter, which are accordingly disposed of. Yes. No, but you had filed a writ petition challenging the notice issued by the police, asking you to give details. This court said that the notice can't be said to be excessive. You will have to comply with the notice. What is the error in that order? What has happened in the last 5 years? No. What has happened in the past 5 years? Do you have any idea as to what exactly has happened? Yes. Now, what is wrong with this order? I'm unable to understand. What is the error in this order? This order only said that you had been issued a notice. You will have to go give a reply to that notice for them to take further action. In tappéನಾಗಿದೆ ಈ order ಅಲ್ಲಿ?
The way with the order from police.
I understand that on the merits, but this order is already passed. What is wrong in this order? This order only said you can go give a reply. There is only the copy of the order. No, you cannot re-argue the writ petition. If there's something wrong in this order, you tell me what is wrong in this order. Some error which is apparent on the face of the record. What is the error? Right. Only if you go give that reply to the police, can they take further action? Can they convict him on the basis of a complaint? They'll have to inquire with you. They will have to ask questions from you. And only if they get an answer suitably, they will proceed further. What was a police notice asking you to furnish information and details? Why can't you give one more reply to that effect? Whatever details you want is already there in the complaint. If you want any further details, I'll give you those details. You should give a reply to the police, isn't it? What is the point of you rushing to the court? You are coming in the way of the investigation. If you had given the reply, something would have happened by now. For 5 years, you have kept quiet. If you had approached the police with this kind of whatever information they wanted, they would have taken further steps. Correct. If you had given a reply and they had filed a B report, that would have been a cause for you to go to the court again. Then how can you maintain the review after you comply with this order? After this order, if you have given a reply to the police, you have complied with this order and with the notice, then what is wrong with this order? I don't think there's anything in the review. Huh? I cannot sit in judgment over that notice again. That notice is already upheld by this court. If you're agreed by this order, you should have filed an appeal. You have filed a review. If you have to file a review, you'll have to point out some mistake in the order, which is apparent on the face of the record, which had led to a wrong order being passed. What is the error? Yes. Give me the notice. Next year D. Copy code notice. Next year D coding. ಇದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ ನೀವು ಎಲ್ಲಿ he has given a reply. What have you done? No, after the crime was registered, you gave a notice to him, and he asking for certain particulars. He has given a reply. No, he has given a reply even before he filed the petition. This petition was disposed of when? What has happened for the past 5 years? Nanen order madala. I'll simply say relist on by which time the learned AG to secure instructions. Demand. ಏನಾಯ್ತು ಅಂತ ರಿಪ್ಲೈ ಅವ್ರೇನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿರೇನು ಅಂತ ಲೆಟ್ ಹಿಮ್ ಫೈಲ್ an affidavit. ಯಾವ್ದ ಸೈಟ್ ದ yes. ಇಲ್ಲ ಬಟ್ ಫೈಂಡಿಂಗ್ ಏನ್ ತಪ್ಪಿದೆ ಹೇಳಿ. You cannot re-argue the appeal on merits. You can't re-argue the matter. He errors are correct. Should have been Sidgampa continued that Kamlappa and the Barivike. It is pointed out in para 5 that there's an error. And instead of stating Sidgampa had contended that Kamlappa had agreed to purchase the suit property, it has been stated that Kamlappa had contended that Sidgampa had agreed to purchase the suit property. So it is also stated that in the very same paragraph, it has been erroneously stated as and had also issued a post-dated check for rupees 1 lakh in favor of Sidgampa instead of issued a check for rupees 1 lakh in favor of Sidgampa. These are inadvertent errors and therefore are corrected. It is there in the agreement. ಒಂದು ಐಟಮ್ ಸ್ವತ್ತಿಗೆ ನನ್ನಲ್ಲಿ ದಾಖಲೆಗಳು ಇದ್ದು ಉಳಿಕೆ 2 ಮತ್ತು 3ನೇ ಐಟಮ್ ಸ್ವತ್ತುಗಳಿಗೆ ನನ್ನಲ್ಲಿ ದಾಖಲೆಗಳು ಇಲ್ಲದ ಕಾರಣ ನಾನು ಸದರಿ ದಾಖಲೆಗಳಿಲ್ಲದ 2 ಸ್ವತ್ತುಗಳ ದಾಖಲೆಗಳನ್ನು ನಾನು ನನ್ನ ಹೆಸರಿಗೆ ಹೊಂದಿ ಕ್ರಮವಾದ ಪತ್ರಗಳನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ಮಾಡಿಸಿಕೊಂಡು ನಿಮಗೆ ಲಿಖಿತವಾದ. So he said I will get the documents in my name and thereafter issue a legal notice. What have I said? Kamlappa stated that as per the terms of the agreement, Sidgampa was required to get the title over item number 2 and 3 of the property and intimate him within 2 months. Another error is pointed out in paragraph 7, stating that the agreement stipulated that Sidgampa was Kamlappa was required to keep the sale consideration ready. In my view, this contention is incorrect, and the amendments in paragraph 7 are a reflection of the terms of the agreement. Apart from the corrections in paragraph 5, I find no reason to entertain this review, and the review is accordingly dismissed, subject to the corrections being made in paragraph 5 as stated above. ಏನಾಯ್ತು? ಹಾ. ಯಾವ್ದು ಹೋಗ್ತೀರಾ? The parties agreed that they will they'll present themselves before the media center at Mysore on 5th of April. Release this matter on 10th, 11th. They had told us that they will get them on that day before. They are ಇನ್ನೊಬ್ರು ಯಾರೋ ಬರ್ತಾ ಇಲ್ಲ ಸಿಸ್ಟರ್ಸ್ ಏನೋ ಅಂದ್ರಲ್ಲ. ಬರ್ಸಿ ನಿಮ್ ensure that it is done. ರೆಡಿನಾ? ಹಾಕಿದಾರ? ಯಾವಾಗ? ಇದೆಯಾ? 14 March. ಇಲ್ಲ. It stated that certain documents application. ಏನ್ ಹಾಕಿರೋದು ನೀವು? Stated that memo is filed enclosing certain citations and certain circulars. Office to put up and relist on. In matter ಏನ್ ಹೇಳಿ first. What is the matter about? Yes, what is wrong with this order? Date code.
Other others?
You are for the? No, father yaar. You are for the sons. You are for the father. Father. What is the order that is passed? Can't give 2,000 rupees to your mother. 20? Yes. It was filed by Sumita. That is a sister. And the two of you. And the first petitioner and what was the subject matter of this suit? Who's staying in this house? Now, was a final decree drawn up? Final decree has been drawn up. This is an ex parte order. Who had challenged it? What has happened? You have 20 acres of land, isn't it? What do you people do? ನೀವೇನ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ 2,000 ರೂಪಾಯಿ ಕೊಡಕ್ಕಾಗಲ್ವೇನ್ರಿ? ನಿಮ್ ತಾಯಿ 2,000 ರೂಪಾಯಿ ಕೊಡಕ್ಕಾಗಲ್ವಾ? ನಿಮ್ 3 ಜನ ಇದ್ದೀರಾ. I'll dismiss this writ petition. ಅದೆಲ್ಲ ಆಯ್ತು, ಆಮೇಲೆ ಅದು ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಏನೋ ಹಾಕೊಂಡು ಹೋಗುತ್ತೆ. ಕಾಂಟ್ ಯು ಪೇ 2000 rupees? ವಜಾ ಮಾಡ್ಲಾ? ಅವ್ರು ಕೇಳಿದ್ರೆ ಆಗಲ್ಲ ಅಂತಾರೆ, ಕೇಸ್ ಹಾಕಿದಾರೆ ಅವರು. For 2000 rupees, why do you want to fight? Legality is one thing. If your mother is 80 years, for how many more years will she live? ಏನ್ ಮಾಡ್ಲಿ? Day after tomorrow. Day after tomorrow, first time he is asking for time before me. If it does not come out with a settlement, I'll dismiss it. ನೀವು ಬರ್ಲಿಲ್ಲ ಅವತ್ತು ಅಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ. I read day after tomorrow. What is the matter about? Not consider the petitioner submits that the subpoena of the writ petition is become infectious. According to such submission, writ petition is dismissed and become infectious. ಏನಿದು? ಮ್ಯಾಟ್ರ್ ಏನು ಅಂತ? ಯಾರು? The wife and children. What is the order that is challenged? ₹7,000, 9,000, 9,000. What is your husband do? ಅವ್ರು ಹಾಕಿದಾರ ಕೇಸು? What does the husband do? Or respond number? Whose number? Committee hanga sotogata. What has happened to the main matter? You are your first respondent, ga? Who appears to the work board?
Your Lordship, for the Waqf Board, Your Lordship.
What has happened to the main matter?
Your Lordship, as far as my instructions are there, inquiry officer is not appointed till now. And I have requested to the Waqf Board that inquiry officer to be appointed as soon as possible, because last time 22nd February, I had instructed, Your Lordship. Now, till now, instructions are not there.
This order was passed by the inquiry officer himself, visited on 23rd of May 2017.
Yes, Your Lordship, the impugned order at annexure A.
For 5 years, there was already an inquiry officer. What did he do? This was only an interim order, isn't it?
Lad, I will submit, my lad. It is an interim order for status quo, my lad. Inquiry is pending. Without inquiry, my lad, this order has been passed without any application. Your Lordship, kindly see.
This order has been in force for the past 5 years.
5 years, activities there is no construction at all.
But I will direct the inquiry officer to conclude the inquiry within 3 months.
Yes, well, that is
Yes,
Until then, maintain the same status.
There is no
Yes,
illegal activities. Since 1904, from the Mysore Registration Act, we are continues to be in a portion. The burial ground as well as the school is also maintaining.
The petitioner has been directed to stop the construction work and to maintain status quo until further orders. This order was passed on the 23rd of May 2017 and has been in force for the past nearly 6 years. In my view, it would be appropriate to direct the inquiry officer to conclude the inquiry within a period of 3 months from the date of receipt of a copy of this order. And until then, the interim order shall continue to interim order granted by him on 23rd of May 2017 shall continue to operate. It is made clear that if an inquiry officer has not been appointed, the Waqf Board shall take immediate steps to appoint the inquiry officer within a period of 2 weeks from today. We read putting according to this process.
much obliged, Your Lordship.
What is the matter about? What has happened to the inquiry? Stay there. What is wrong with this? What is the illegality in the charge sheet? You can go give a reply, isn't it?
Not to the panel.
That was the
Yes, Venkatesh.
show the name of Venkatesh Arbati. It's appearing correspondence. Released on. The point further on is illegal. In the meanwhile, they should be interim stay on there.
My lord, I present the petitioner, madam, seek some accommodation. The respondent has to file the objection statement, it is not yet filed.
What is the matter about?
The cancellation of the allotment of industrial land, my lord.
Cancelling the allotment.
Yes, madam. And forfeiting the advance amount.
Why was it cancelled, madam?
He was not paid on time. Within time frame, they have to pay the EMP. So not paid the subsequent amount. Within 20 days. They mentioned in the allotment, they don't pay. Thereafter, subsequent time has been informed, and then they have filed an application for providing allotment on the next side. So that application, that has not been traced by the petition. Thereafter, we have senior citizens have not paid. Is challenged before
When was the allotment made?
allotment dated at page 12, 29 to 2016.
Short accommodation may kindly put on, madam. I'll argue matter on this some other day.
How much had she deposited? 20%.
90 lakh was paid by them undisputedly. The balance 2 crore 10 lakh was the 90 days gets over in May, 29th May. Thereafter in July, we issued the letter saying that please provide us alternate time. That is on 19/7/2016. After that period is over. Thereafter, my lord, since there was no payment made for the balance amount, we went ahead and we canceled the allotment on 2/3. That is challenge.
But if they don't want the site, why can't you just return the money to them?
She's been signed by both the parties.
What was the site that they wanted? For what purpose?
Industrial.
7 months. They were supposed to pay within 90 days. They should have paid that amount and then asked for an alternate. That also not done. They did not pay anything. And then, yeah.
They paid almost 1 crore rupees. Almost a crore.
The allotment letter.
They did the request for allotment of alternative site. Now, are you prepared to give an alternative site? Are you prepared to give them an alternative site? Again, madam.
My lord, little inconvenience is there because my specs is not there, my lord. I can't read the papers. I am short accommodation may kindly be given.
No, if you're prepared to pay the interest, I'll ask them to cancel the allotment and allot it to you. Illandre you will
Yes,
lose
madam.
that entire money.
Yes, ma'am. I'll talk to my client and come back, madam. If they are ready to
Yes,
pay
madam.
the interest of the balance amount.
Also states that she has entered appearance on behalf of KDB. Her name be shown in the cause list and the name of the PV Chandrasekhar will be deleted.
ಜಾಸ್ತಿ ಬರ್ತಾ ಇಲ್ಲ.
ಮಾತಾಡಬೇಡಿ ಒಂದು ನಿಮಿಷ.
ಅಷ್ಟೇ. Who appears for SBI? Who is the standing counsel for SBI? ಸರ್ವೋಚ್ಚ ಮುತ್ತನ ಬಂತು RFL ಮುತ್ತನ Dinesh is directed to take notice for the respondent. Copies be served on a pre-list on. What is the next area? आपकी बाड़ीगे वसूलात. Now, were they heard before this? Adidra. Student Nakidra. What is the basis for this 18,53,000? The ಎಷ್ಟು ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಯಾವಲ್ಲಿಂದ ಕಟ್ಟಿಲ್ಲ ಅವರು paragraph 10 of your objections saying that they express their intention of handing over the theatre with effect from 1/3/2012 as per letter dated 4/2/2012 with respondent number 2 and express their inability to pay rent from 24/6/2011 as their entire business activity was stopped. And next paragraph further submit that in response to the letter of the petitioners, respondent number 2 addressed a letter dated 10/5/2012 to respondent number 3 directing him to take over steps to take over the property. Why do you not take over the property then?
After the break not silent is there, break on that cannot be after.
Reputation at WP 353452 ಏನಾಯ್ತು? What happened to the other reputation 3452? ಏನಂತ? ಏನಂತ? No, but if he had said that he was not interested and requested you to take over, and you had said you will be taking over, how can you ask for rent again?
My lord, this is serial number 23.
Yes.
I am for the petitioner, my lord, in this matter. My lord, just 2 days time, senior is not there, and I have some inconvenience to address myself in this matter. Not fully prepared, my lord.
Let's find out what happened. Respond. Subsequent development.
Lord, in this case, my lord, I am appearing for the serial number 24. Lord, serial number 24.
1 minute. Yes.
My lord, I have filed an application for modification of the order, my lord. In pursuance of the decree, my lord, the petitioner has sought his name, the entry in the RTC, my lord. The authorities have issued an endorsement as per Annexure A, which is challenged before your lordship. Now, my lord, your lordship, after hearing the government advocate, as well as the petitioner was pleased to pass an order on Lord,
27th of June.
Yes, 27th of June. My lord, thereafter, I gave a representation to the revenue authorities and also got issued a legal notice, which your lordship will get it in the application itself. My lord, Annexure H.
1 minute, 1 minute.
My lord, they are not in. They say, my lord, they say, I have not issued a legal notice saying that in case entry is not done, my lord.
Tahsildar?
Tahsildar Bantwal.
The Tahsildar to file an affidavit as to why the order dated 27/6/2022 is not complied with. If the affidavit is not filed, the Tahsildar shall be present in person. Call on.
Third. Yes. Yes.
So the petitioner. This is the main matter. Annexure F. Annexure F.
Previously, they have challenged. Subsequently, they have amended and challenged the auction notice also. about the ASMC may go to on 19/1/2010, the notification issued for auction of the property. The petitioner
Is there any interim order in this writ petition?
Because my lord, I have paid the 26 lakh 70,000 year of 2010. They are not rich. Even this writ petition itself is not maintainable. Status quo starting argument. All the
The purchaser,
have paid in the year of 2010, 26 lakh to 70,000.
qualified purchaser irukara.
Even the JSFC also given several opportunities to the commissioner to pay the bills amount. Moreover, one-time settlement, they have not paid single pay ticket. JSFC is also.
Sale it register ಆಗಿದೆಯಾ? Sale it register.
Also, my lord, at the time of auction, I have paid 20%. I am now thereafter, after the degrees have paid again 99 lakhs. Total, I have paid 26 lakh 70,000 out of 60 lakhs. Thereafter, my lord, this is the case has to refuse to take amount, my lord.
Let me look at the order sheet first. What exactly is that?
ASX is also paid an amount of 6,900 and 2021. One-time settlement target to 2021. Today they are not paid. Simply may not taking time.
How much have you deposited? Yavaga? But that air council on record. No, I dismissed the petition because there's no point. 71 lakhs 92,000 you were supposed to pay on or before 3rd of June 2022. ಅಲ್ಲ ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿರೋದು has already been considered and as per the same 71,92,056 is payable within 90 days from 4/3/2002 which is going to expire on 3/6/2002. Thereafter statements are made by KSFC that this money is not deposited. What is it that you can do now? More. ನೀವು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ? Tell them if they are not prepared to pay 71 lakhs with interest, it will go. Gita Menon. ನೀವು ಯಾರಿಗೆ? Phone number? What is the challenge here? Next E. Did they have an interim order here? Yes. Don't you have an appeal against that order? Don't you have an appeal against that order? Next E alva. MP notice annexed E, isn't it? Page 41. You are not a party in the proceedings?
On number 4 is the party because the competent authority.
Then I set aside this order, hear them and pass the orders. You admit that they are in possession.
They are not in possession. They are claiming is different property. The party is order passed in this order number 20 see the payment of 37. All the pieces parcel of the property.
But this respondent has not challenged it. Amanullah has not challenged it.
Not correct.
What is your property, madam? Very madam.
There is no notification.
Now the order says that there is a notification.
You are you notification. No.
Which provision in This is in respect of work which has not been. Time back ನಿಮ್ಗೆ. So this was notified under the old act, under the 55 Act. No, under the old act, there was a publication of this particular property as work property.
They had a degree there. Chief court degree. Real estate control. But all the things are there on the details. Here they have. Primary thing is not.
That is what they say. The petitioner has produced a copy of the notification number so and so dated 7665. Next year. Serial number ಯಾವ್ದು ಹೇಳ್ತಾರೆ ಅವರು? #81. Arcot Srinivas Church Street, Cross. Where is this property situated? ಅದೇ ಹೇಳ್ತಲ್ಲ ಹಸ್ರತ್ ಅಲ್ಲಿ ಬರ್ದಿರೋದು ಇಲ್ಲಿ ಅಶೂರ್ ಖಾನ in the premises of Dargah Hazrat Sute Shah Suni, Arcot Srinivas Street, Cross Road. Hazrat Sate Sune Shah Dargah Compound, Police Road, Cross, Bangalore. It is the same Dargah, isn't it? No, they have not given. No, they have not given any number here. They have not given. They have not given any number. The simply.
Schedule not even number is clear.
ಇಲ್ಲ ಮೇಡಮ್ schedule ಬರ್ದ್ರೆ ಇಷ್ಟೇ all that piece and parcel of the property situated at Hazrat Sote Shah Dargah compound police road cross Bangalore. No number is given, nothing is given.
Number 101.
That is your address where you are staying.
Schedule. They were finally scheduled.
What is your right to be? I am not very sure about that argument because if the under the old act it was notified. No, it talks about that if the waqf has been created before or after, it does not relate to a waqf which has been published in the. No, you will be bound by the repealing. Yes, in respect of those waqfs.
That created before.
Ado, no. Those waqfs which are not yet registered, after this act, they have to follow this procedure. But in respect of waqfs which have already notified under the old act. Then what should happen to the repealing provision, which is anything done under the old act will still be valid? Yes, there is a repealing provision.
Because after 95, any land which is modified as must be registered.
That is not what, that is not the import of section 36. No, that illa madam matra illa.
Station pertaining to what are the properties which has not been registered prior to the 1995 Act and the 2013 Act. Those properties have to be registered under section 36. Right, madam. But my learned senior is arguing the matter. It is already notified the work property, serial number 284, the 1965 law. The order is passed under section 5 of the Karnataka Public Premises Act. But we kindly see the Karnataka Public Premises Act in 1975 Act. Any orders is passed under the section 5. They should be challenged under section 10 of the Karnataka Public Premises Act.
But they are saying that they are not parties to this order.
They are not in parties in the suit, my lord. They are unlessly they are challenging this order. They are challenging this order. They are paying for it. They are not in this annexure T only.
Right, annex, but if the annexure is passed against some other person and you use that order to dispose him, then that will be wrong, isn't it?
A clarification from the board, my lord. I have it the day after tomorrow, my lord. I'll explain.
ನೀವು ಬರಕ್ ಹೋಗ್ಬೇಡಿ, ಅವ್ರು ಬಂದ್ರೆ ಸಾಕು.
I take this
After tomorrow.
from the board.
No, I am not in agreement with your argument, madam. That can't be correct. That is on the merits, but on a question of law. Let us see what he will say. Matter and money. What is the matter about? What is annexure G and H?
Send that a lot and thereafter connected to recover the amount. Okay.
PVR ಗೆ ನೀರಾವರಿ.
Successful bidder, my lord. Tender as
Annexure G is cancellation of the contract.
Yes, sir.
What is annexure H?
Excellent is with regard to the ಗುತ್ತಿಗೆದಾರರಿಂದ ಇಲಾಖೆಗೆ ಬರಬೇಕಾದ ಬಾಕಿ Lord, here is the case, my lord, on 30/6/2011 ಮಾಡೋದಾಗಿ deposit 10,15,000
ಯಾವತ್ತು?
within 2 weeks, my lord.
ಯಾವತ್ತು?
On 13/6/2011, when they approved before this annual court by following this petition, there was an interim order to that effect.
Bank guarantee.
Yes, sir. But they have changed the government. And you will also get to see.
Then why did you not take any coercive steps? Why did you keep quiet? Why did you keep quiet for 12 years? You wanted to help them, that's why you kept quiet.
Instead of so many.
This interim order was a conditional interim order. What prevented you from ಸಹಾಯ ಮಾಡೋದಕ್ಕೆ? Please read annexure H. What is wrong? This is a communication to their engine. You are one among the contractors. Admittedly, the contract is cancelled. And there is a communication to forfeit. No, the communication is internal communication, saying that if there are any EMDs contracts for which payments are to be made to you, that amount not be given to you and that amount be remitted to the board. How do you say that that is wrong? ನೀವು ಅವ್ರು ಸಹಾಯ ಮಾಡ್ತಿದ್ರ, ನೀವು ಇಷ್ಟು ವರ್ಷದಿಂದ ಏನು ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ. You want to help them, therefore you are keeping quiet. 100 ರೂಪಾಯಿ 200 ರೂಪಾಯಿ ಕೊಡೋರ್ನ ಬಿಡಲ್ಲ, ಹೊಡೆದಾಕ್ ಬಿಡ್ತೀರ ಅವ್ರು. 90 lakhs you are keeping quiet. Day after tomorrow. What is the matter about? Notices. What is the notices? Pictures Q to Q30. Electropathy and electrohomeopathy. You have an interim order here. Who appears Nero? What's your contention? What exactly is your stand now? Because the interim order indicates that so long as they do the electrohomeopathy, you have no objection. They should not distribute allopathic medicines in the sterile condition. This final order, this Saka. It's a 2011 matter, 12-year-old matter. Next Monday.
If it is 29, I am for respondent number 2, Miller.
R2 Garilva.
R2 Gnano.
Nimdala.
Sorry.
28 altane.
Just 28, 41, 731,
R2 Nimdana. Shivanand accepts notice on behalf of R2 also. $28. ಎಲ್ಲ ಕಡೆಯಲ್ಲೇ ಲೈವ್ ಸಿಗ್ತಿಲ್ಲ ಮೇಡಮ್. ಯಾವ್ದ್ರಲ್ಲಿ? ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಲ್ಲ? Office to delete the name of ASG for R3 since Shaman Kumar. has entered appearance on behalf of the union. ಎಲ್ಲೆಲ್ಲಿದೆ ಅದ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲೆಲ್ಲಿ ಏಜ್ ಇದೆ ತೆಗೆದಾಕಿ ಮಾಡ್ತಾರೆ ಬಿಡಿ ಅವ್ರು ಮಾಡ್ತಾರೆ. The interim mode was not restricted to any time. There's no time limit.
In serial number 29, I am for respondent 2 man.
Yes. What is the matter about? ಏನ್ ಮ್ಯಾಟರ್ ಆಶಿಕರ್ ಅವರೇ?
ಹೌದು, ಇದು ಈ RV College of Engineering, whether it is public authority or not is the question. That has been decided by the commission, which is challenged in these 2 writ petitions.
ಅವ್ರು ಆಗ್ತಾರ ಅಥಾರಿಟಿ ಆಗ್ತಾರ?
ಆಗ್ತಾರೆ, and I have produced, I have filed my detailed statement of objections on 15/4/2013, and
ನೀವ್ ಯಾರಿಗೆ?
Respondent number 2, the complainant.
Sought for information.
How?
ಅಲ್ಲ, ಒಂದು private engineering college also will become an authority under the act.
ಹೌದು, ಆಗುತ್ತೆ. In fact, several citations have been furnished, including the latest judgment of this honorable court. ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. 1-21 I have filed the points for consideration along with all the citations, and 15/4/2013 itself I have filed statement of objections along with all the documents. ಅದನ್ನ ತಾವು ನೋಡು ಮಾಡಿದ್ರು ಸಾಕು, ನಾನು ಒಂದು ಓರಲ್ ಆಗಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳೂ ಇಲ್ಲ. ಇನ್ನು ಅಫ್ಕೋರ್ಸ್ ಅವರು ಏನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರ, ನನ್ನ ಪಾಯಿಂಟ್ಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ದಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಪಾಯಿಂಟ್ಸ್ ಅನ್ನು ಹೇಳಿದ್ದೇನೆ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ, ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
Which section are you relying upon under the act?
ಅವರು ಪಿಟಿಷನರ್ ಏನೋ ಇದ್ದಾರೆ ಅಂತ ಕಾಣಿಸ್ತಾ.
ಅಲ್ಲ, ನೀವು how do you say that it's a public authority?
Yes. Under 2H of the right to public authority. 2H.
Yes. Means any authority or body or institution of self-government established or constituted A, by or under the constitution, B, by or by any other law made by the parliament, by any other law made by the state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled or substantially financed, NGO or substantially financed directly or indirectly by funds provided by the appropriate government. How do you bring them within this?
Because they are substantially financed by the government. In fact, I am supported in saying so by several judgments of this honorable court which I have produced. Kindly take the points for consideration filed by me. ಮೊದಲನೇದಾಗಿ ರಿಟ್ ಪಿಟಿಷನ್ itself is not maintainable. ಯಾಕೆಂದ್ರೆ they have challenged 2 orders. It is filed on 1/2/2021.
Is an aided college, unaided college either? Aided college, unaided college either?
Unaided engineering college. Under this public authority ಅಂತ ಹೇಳಿ ನೋಟಿಫಿಕೇಶನ್ ಗವರ್ಮೆಂಟ್ ನವರು ಹೊರಡಿಸಿದ್ದಾರೆ. ಅದನ್ನ I will take your lordship through the documents.
Yes.
ಮೊದಲನೇದಾಗಿ the first point is that they have in this 13,784 of 2013 they have challenged annexure E, the order dated 15/11/2011 passed by the Karnataka Information Commission in application number 1413 of 2011.
Yes.
The challenge to the said order is not maintainable, sustainable for 2 reasons. The first point, there is unexplained, deliberate and intentional delay in challenge in the said order. Annexure 2011 ದಲ್ಲಿ ಮಾಡಿದ order na they have filed the petition in 2013.
It's a question of jurisdiction. It's a question of jurisdiction. You satisfy with the jurisdiction. if the information commissioner lacks inherent jurisdiction, then
My
the question of delay would not be really relevant.
ಅಲ್ಲ ಯಾರು ಅಪ್ಲಿಕೆಂಟ್ ಆ ಕೇಸ್ನಲ್ಲಿ ಅವರನ್ನು ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ ಇದರಲ್ಲಿ.
ಅಲ್ಲ ಅದಿರ್ಲಿ, ಫಸ್ಟ್ ನೀವು jurisdiction ತೋರಿಸಿ ನನಗೆ.
Yes. I thought he would submit the arguments. ಹೀಗಾಗಿ ನಾನು I am not fully ready. And if necessary, your lordship may kindly go through this points.
Next Monday.
Please.
What is the prayer and the writ petition? Next year. Then KLR matter. Next Monday. Next.
Not serial number 29. I'm
Next
sorry.
Monday.
ಮಂಡೇ ನನಗೆ ಆ ದಿವಸ ಏನೋ ಸ್ವಲ್ಪ ತೊಂದರೆ ಇದೆ. ಮಂಗಳವಾರ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ. Fifth, please.
ಏನ್ ಶಿವಾನಂದ್ ಇದು? Consider the request annexure F. This is a request to appoint some special, not a page 91. Request is to appoint a special government advocate. For what purpose? Is there 781? Then 480 to the. This is the normal. Who appears for the petitioners here? 50781. ಏನಾಗಿದೆ ಗೊತ್ತಾ ನಿಮ್ಗೆ ಕೇಸು? CC. Right. What is the allegation in this case? They are challenging the but in the second matter, they're seeking for quashing of the proceedings. Quashing of FIR number so and so, charge sheet CC 5321. Interim order ಇದೆಯಾ? Order ಇದೆಯಾ? 5078. Please inform them next week. Where is so? What is annexure B? Ready ನೀವು? They will not fail. Are you ready? Next one. What amount? What is the amount that was to be paid? Who are you? Did you get the main amount or not? Was it paid voluntarily or pursuant an order of the court? Where is the order of the court? Nothing to do about the payment here. Yes. But the amount was withheld because of some allegation against you. So it is not like as a deliberate withholding so that they'll have to pay interest. Without any reason, they did not withhold. There was some inquiry being conducted. There is the order to complete the inquiry within 3 months. Six months. This was on 22nd of July. Yes. When did you file the contempt? So 6 months is they had to complete before 22/9/2010. This order is passed on 25th of March 2011. So, 1 minute. In this amount was paid 4 lakh. So the delay, even according to, is roughly about 6 months. That is all. From 22/9/2010, they were supposed to conclude the inquiry. They conclude the inquiry by 25/3/2011, and paid the money on 4,89,000. So just for 6 months, you are now claiming interest? Maybe so, but the direct, at your instance, this order was passed. No, this court said you are granted interest, you are granted the liberty to claim interest on this amount. For the delayed period of withholding, you are entitled. I'm not for a minute saying no, but the direction was to hold an inquiry. And the time to conclude the inquiry was 22/9/2010. So from that date, no, 22/7/2010 was the order. 6 months time was granted. It expired on 22/9. The money is paid to you on 25/3/2011. Which is that amount? There's no reference to that in the contempt about any further amount being due. Page number? What is this? What is this 124? This is in respect of some other period, not in relation to the inquiry. No, this contempt that you referred to, Annex RF, what was that 4,98,000? Where is it said about the remaining amount should be paid after the inquiry? Because the statement in this particular order at page 71 says, today a counter affidavit is filed stating that the inquiry is complete and the sum of rupees 4,10,100 is the amount payable to the complainants by the respondents. Where is it said? It is tentative and some other inquiry was still complete. This contempt was filed to punish them for which order? Disobedience of the order passed in the other writ appeal, isn't it? The other writ appeal simply stated, similarly, it is for the writ petitioner to extend the bank guarantee offered with the writ petitioner till the inquiry is completed. This WP 221 by 2007 and WP 6501 by 08. Which is that? What is the direction in this? Where? Which paragraph? As against which this writ appeal was filed. Writ appeal 339. 6 months. Now the contempt that is filed was pursuant to this order only. So in the contempt, a specific statement was made, which you accepted that the inquiry was complete and 4,98,000 was paid. Where is this argument of a further inquiry being conducted? No. The order that you indicated was inquiry should be completed within 6 months. It was completed a bit belatedly and the money is paid to you. Where is it said in this order that some other money should be paid to you? Where was your contention in the contempt? Then how can you say it was withheld? The direction was only to conclude the inquiry. The moment the inquiry is concluded, whatever money was due to you was paid. Interest on what? On the money that is due. The money that was found to be due was 4,10,000, which you accepted. You never raised any contention. Further sums were due in the contempt. Where have you said that further amounts were due? If any further sums are paid to you belatedly, how can you relate it to the contempt? Nagat Bhatter, you should have made a statement clearly saying that I still, they still owe me 18 lakhs, 16 lakhs, and that money is not paid and permit me to collect interest. ಬಂದಿದೆಯಲ್ಲ ಬಿಡಿ ಕಾಸು ಬಂದಿದೆಯಲ್ಲ ಅಟ್ ಲಾಸ್ಟ್ ಅದರ ಬಂತಲ್ಲ. That is there is no direction regarding any further sums due. Wait, let him finish. Then what is this page 128? There also the finding is entire amount has been paid. Then what is this again? You want to claim interest? You don't say anything when the money is given to you. Afterwards, no, please read page 126 order. Page 127. Their only claim was 1,63,000, and that they said was to be adjusted towards the income tax or something. Bani madam. challenging annexure P. Page number. The petitioner is challenging annexure P, by which the demand for payment of interest for the EMD amount and the bank guarantee amount has been rejected by the Commissioner of the Social Welfare Department. It is not in dispute that there were several rounds of litigation in relation to the claim of the petitioner for payment of the amounts due to it for imparting vocational training. Ultimately, in CCC 1638 by 2013, this court recorded the following finding, paragraph 3, page 128, paragraph 4. As could be seen from the said order, before the in the contempt proceedings, the petitioner did not dispute that the entire amount due to it had been paid. And in the light of this undisputed position, this court dropped the contempt proceedings. Since the petitioners never contended before the contempt court that they were entitled to payment of interest, and they in fact admitted that they had received all the sums due to them, it would not be open for the petitioners to seek for payment of interest on the amount due. So in that view of the matter, the commissioner was justified in refusing the claim for payment of interest on the EMD amount and also on the bank guarantee furnished to it. I find no reason to entertain this additional is accordingly dismissed. The matter है ना? In annexure ये है ना? This happened to the main matter.
Manoj was dismissed. He files an appeal. Appeal is withdrawn by him.
Divorce was refused. Main matter itself is gone. Why are you fighting? If the main matter is disposed of, will the interim order serve? Then prefer an appeal. Don't suffer an order from my end. Yes. Where is the application that she filed for maintenance? Yep. Day after tomorrow. Thank you, the petitioner. Sarai Sharif. Pre-litigation. 1 minute. Where is the circular? Lecture? Come to the last paragraph, page 14. As such, the branches are advised to make best use of this offer and ensure that none of our existing customers having housing loans under the standard asset shift over to the other banks. So it was a duty of the bank to ensure that all the concerned customers are given this option. Did you give this option to them? This was a voluntary circular. You were afraid you will lose customers. Therefore, your head office said, do not lose the customers, ensure that the switchover happens. So was it not the duty of your bank manager to inform all the people who have taken the loan of this benefit? Can you? When was it informed? When was it informed? When was the circular informed? Displayed better. Display better. This was your voluntary act to retain customers. You knew the number of customers who had taken the loan. Was it not incumbent upon you to inform everybody? Where is the government that you informed them? Your argument is that you had put it on the notice board, they had to come and see. Which customer will go and look at the notice board? ಎಷ್ಟಾಗತ್ತೆ ಬೆನಿಫಿಟ್ ಅವ್ರಿಗೆ? ಎಲ್ಲರೂ ಕೂಡ ಬೆನಿಫಿಟ್ ಅವರು ಕೊಡ್ತಿರೋದು, ನೀವೇನು ಎಕ್ಸ್ಟ್ರಾ ಏನು ಕೊಡ್ತಿಲ್ವ? Yes. Yes. What was the amount that they lost by virtue of this? All right, I will ask them to pay this 1,36,410. You give them the benefit. I will pass an order saying that this becomes an obligation on your part to inform all the customers. Having not done that, there's a deficiency in your part. Yes. Yes. Did you raise the contention before the local Adalat that it has no jurisdiction? ಅಲ್ಲ ಸಾಲಕ್ಕೆಲ್ಲ ಅಲ್ಲೇ ಬರ್ತೀರಾ ಅದು ನಮ್ಮ PLA ಸಾಲದ ಕ್ಲಿಯರ್ ಮಾಡಿ ಕ್ರೆಡಿಟ್ ಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ಅವರೆಲ್ಲ ಬರ್ತಾರೆ ಅವಾಗ ಅಪ್ಲೈ ಆಗಲ್ವಾ ಇದು? ನಮ್ಮ PLA ಅಲ್ಲಿ ಬ್ಯಾಂಕ್ಸ್ ಎಲ್ಲ ಬಂದು ಫೈನಾನ್ಷಿಯಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ PLA ನೀವೇ ಇನ್ವೋಕ್ ಮಾಡ್ತಿರಲ್ಲ. ತೋರ್ಸಿ ಅವ್ರಿಗೆ ತೋರ್ಸಿ. ಇದೆಯಲ್ಲ ಬ್ಯಾಂಕಿಂಗ್ ಅಂಡ್ ಫೈನಾನ್ಷಿಯಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂತ ಇದೆಯಲ್ಲ. Clause 7. The 5-7. Banking and financial institutions. Ate bidi ಆಮೇಲೆ next. $1,36,000 ಕೊಡಬೇಕಾಗುತ್ತೆ ನೀವು. If you want it from that date, you have to pay that 1%. That 1% everybody else has paid. Those suppose they had given you an option in the year 2013 and you had sought for changeover, you were obliged to pay that 1%.
Because it is floating rate of interest.
Oh, have they waived it to everybody?
So only those who
Correct, Mahabaleshwar ಅವರೇ? ನೀವು ಎಲ್ಲರಿಗೂ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮಾಡಿಲ್ವ 1%? File an affidavit to that effect. I will ask him to pay the changeover. Then the difference you pay. 1 point ಆಯ್ತಲ್ವಾ? Subject matter of dispute is rate of interest, not the loan. They have no problem with the loan. They are only concerned about the reduction in the rate of interest. That is the subject matter of the dispute, not the 1.4 lakhs, 1.4 crores. Where the value of the property in dispute, the dispute is only for the reduction of interest for that particular period, 1 year, which is less than 10 lakhs. I will interpret it. 22. 22. Yes. Kindly read 22, sir. 22 C8. So they've decided. If there is a possibility, if it is not there, then they decide. Relitigation Lila, this is not a suit. These are admitted facts. Loan is given. Admitted fact is that you agree to reduce the loan, the interest of the loan. The only question is, can you put it on a notice board and say, I've informed? From the day on which you intimate them. If you don't intimate them, it will be from the date of the circular. How will they know? They say that we came to know about this, we approached the manager, asked us to go to general manager, then thereafter we gave the letter. The fact remains that you have not intimated them.
Then they brought it to the notice.
If you want to argue, then I will say I will not touch it 1,36,000. I simply confirm the order. You lose at 1,36,000 also. If you have waived that interest to everybody, you have to give the same benefit to him.
It was given.
But he says that, but he's saying that the same benefit is given to every other person who had started switchover.
The date of circular is.
Clearly. Continue at 2:30. One matter, Nikidale. Take it up at 2:30. $38. Yes. It will be repeated again next Monday. Next month.
If possible.
Next Monday. ಇಲ್ಲ next Monday repeat ಆಗುತ್ತೆ. ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ವ
Sir. Court officer.
ಮೇಡಮ್
ಸರ್ 21 ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು ಯಾವತ್ತಿಗೋಯ್ತು ಸರ್?
21.
ಹೌದು
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
ಮಂಡೆ ಸರ್, ಅದು ಆಪೋಸಿಟ್ ಕೌನ್ಸಿಲ್ ಏನಾದ್ರು ಫೋನ್ ನಂಬರ್ ಏನಾದ್ರು ಸಿಗ್ಬಹುದಾ ಸರ್?
ಫೈಲ್ ಇಲ್ಲ, ಫೈಲ್ ಹೊರಟೋಗಿದೆ ಅಷ್ಟೇ.
ಹೌದಾ? ಮಂಡೆಗೆ ಅದೇ ಮೇಡಮ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ವಕಾಲತ್ ಹಾಕಿದ್ರು, ಯಾರು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳೋಣ.
ಅದು ಇವರು ಅನುಪರ್ಣ ಬೋರ್ಡೋಲೈ.
ಯಾರು ಸರ್?
ಅನುಪರ್ಣ ಬೋರ್ಡೋಲೈ.
ಅಯ್ಯಪ್ಪ ಏನ್ ಸರ್ ಈ ತರ ಇದೆ, ಕೇಳಿಲ್ಲ. ಮೂಕರಣ ಬೋರ್ಡ್ ಅಲ್ಲ. ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
So serial number 38.
Next week.
Monday, sir.
Yeah.
Okay, thank you.
What should they do according to you? If there is no consent, what should they do? They should ask them to go to the court. Paragraph 4. Did they consider the amendment? 22A consider ಮಾಡಿದಾರಾ? ಇಲ್ಲ ಇದು or did they consider 22A because 22A came about in the year 2002. This was in respect of 1998. 22A, this chapter 6A was inserted with effect from 11/6/2002. Did they consider this chapter 6A? 22A consider. Correct. Under 22, they had no power. Under section 22, you're right, but under section 22A, under this chapter, ಈ judgment apply ಆಗಲ್ಲ. No, but this is without reference to 22A subclause 8, 22C subclause 8. ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಪ್ಯಾರಾಗ್ರಾಫ್? ನಂಗೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ, ರೆಫರೆನ್ಸ್ ಎಲ್ಲಿಂದ ಸಿಗ್ತಿದೆ? Is it a reference to another citation or what exactly? Because this at para 4 it suddenly starts off having heard the counsels for both sides. ಅದೇನು ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟಾ ಇಲ್ಲ ಇದೇ ಜಜ್ಮೆಂಟ್? Mostly this is referring to some other judgment. This is not permanent Lok Adalat, this is pre-litigation. Did you check up on that constitutional judge decision of Supreme Court on this? 22 A ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. Because the validity of this was challenged, saying that there can't be a parallel institution created for the purpose of adjudication. That they have said it's the privilege of the parliament and that can be done. You're saying it can't be done, Tane? Same judge. Same judge, no? About same judge. All right, I will consider. Sir. Hardware. Mahesh avare, serial number 1.
Pray for 2 weeks time not to take steps.
Lala. Our R2.
ಅವ್ರ
ಇದ್ರಲ್ಲಿ ಆಗಿದೆಯಲ್ಲ.
ಅವ್ರು ತಕ್ಕೊಂಡಿದ್ದು ಇಟ್ಸ್ ಕೇಸ್ ಇಂಪ್ಲಿಕೇಟೆಡ್ ಮೇಡಮ್.
ಏನ್ ವಾಟ್ ಇಸ್ ದ ಕೇಸ್ ಅಬೌಟ್?
The case of implication, Lord,
has been served through paper publication in the campaign and appeal filed by the insurer. Notice to R2 is dispensed. Yes.
R2 dispense ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಅವನಿಗೆ ಸರ್ವ್ ಆಗ್ಬೇಕು.
ಕನೆಕ್ಟೆಡ್ ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಮುಖಾಂತರ ಸರ್ವ್ ಆಗೋಗಿದೆ.
ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವ್ರು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ, ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ ಇಟ್ಸ್ ಕ್ವಶನ್ ಆಫ್ ಲಯಬಿಲಿಟಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಸರ್ವ್ಡ್.
ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದ್ದಾರೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಮುಖಾಂತರ. ಅದಕ್ಕೆ ನಾನು ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ ಬೇಡ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ.
ಇಲ್ಲ ನಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ,
ನಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ R4 by order dated 27/11/2018 memo for paper publication is accepted.
Then, my lord, the LCR has come, I am ready.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ.
Question of a vehicle being implicated, it requires a record.
ಇದೆ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ಅಂತ ಅವ್ರ ಹತ್ರ?
ಅವ್ರ ಹತ್ರ ಇಲ್ಲ, ನಿಮಗೆ ಬೇಕಲ್ಲ.
ಅವ್ರದೇ ಇಸ್ಕೊಳ್ತೀನಿ.
ಇಲ್ಲ ಇಲ್ಲ, some other date may be fixed, my lord. I'll get ready and then.
Next Monday.
Please.
As requested, notice to R1 and R3 dispense. ಯಾರ ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಯಾರು? ಏನ್ ಇಂಜುರಿ? ಏನ್ ಆಗಿಲ್ವಲ್ಲ ಹಂಗಾರೆ? ಏನಾಗಿಲ್ಲ. ಸೆವೆನ್ ಡೇಸ್ ಇದ್ರೆ ಹಾಸ್ಪಿಟಲ್. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 10,000 ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ. ಕನ್ವೆನ್ಸ್ 7,000 ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ. 7 ದಿನ ತಾನೆ. ಏನ್ ಸೀರಿಯಸ್ ಇಂಜುರೀಸ್ ಏನ್ ಇಲ್ವಲ್ಲ? In respect of an accident which is not in dispute, the tribunal has awarded the following sums. Being dissatisfied, the claimant is in appeal. So, admittedly, in this case, the doctor who treated the claimant was not examined. No documents relating to the hospitalization of the claimant was also produced. The tribunal has recorded a finding that claimant had suffered grade 2 splenic laceration and mild hemoperitoneum. The evidence on record indicates that the claimant was hospitalized for 7 days. In my view, interest of justice would be served by enhancing the sum of rupees 10,000 awarded towards pain and suffering to rupees 20,000 and awarded sum of rupees 7,000 towards food nutrition and conveyance and attendant charges. Consequently, claimant will pay. Just to take notice. Keshav Prashant. Representative. Keshav Prashant. Cell number 3. Order. Cell number 3.
Pray for a week's time or not to take steps. Fine.
R5 expert will dispense with notice to them.
Expert. ನನ್ನ ಇದರಲ್ಲಿ
Srinivas Reddy.
ಅಲ್ಲ
Srinivas Reddy.
Serial number 4, my lord.
Correct. Srinivas Reddy is R5. He was placed expert in the court below.
Although it requires LCR, my lord. Question of liability. LCR ಬಂದಿದೆಯಾ ನೋಡಿ.
ಏನ್ liability ಏನ್ question?
Two vehicles, my lord, have been involved. JCB and motorcycle.
JCB lorry.
Lorry, JCB.
ಏನ್ liability ಏನ್ question ಇದೆ?
Absolute negligence caused on the deceased motorcycle rider.
Monday, your lordship, kindly have get ready.
Next Monday. Special notice to R1 dispatch.
Vijay Kumar.
Vijay Kumar. ಏನಾಗಿದೆ? $9,500. ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ನೋಡಿದಾರೆ? ಬರೀ ಇನ್ಕಮ್ ಒಂದೇನಾ? In respect of an accident which is not in dispute, the tribunal has awarded the following sums. In order to arrive at this conclusion, the tribunal has determined the disability 11% and has taken the notes to come at ₹6,000. As far as disability is concerned, since the doctor stated that the claimant has suffered disability to the extent of 33% of the particular limb, the assessment at 11% cannot be found faulty. However, as regards income, since KSLS has determined the income mostly at ₹9,000 for accidents of the year 2016, the same will have to be applied. Consequently, towards loss of future earning, the claimant will be entitled to some ₹9,500. 12 multiplier ಎಷ್ಟು? 16 into 11%. ಎಷ್ಟು ದಿನ ಇದೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? The tribunal has awarded a sum of ₹25,000 towards pain and suffering. In regard to the fact that the claimant has suffered a fracture of the femur and is hospitalized for 23 days, the appropriate award is sum of ₹50,000 towards pain and suffering. The tribunal has not awarded any sum towards loss of amenities. Since the claimant has suffered 11% disability, the appropriate award is sum of ₹30,000 towards loss of amenities. Sum of ₹22,000 awarded towards medical expenses is affirmed. Since the claimant was hospitalized for 23 days, it will be appropriate to award a sum of ₹30,000 towards conveyance, food and nourishment, and attendance charges, as against 20,000 awarded at the. As the income is now determined at 9,500, it will be appropriate. The tribunal has taken the later period as 2 months. Since the claimant was hospitalized for almost a month, the appropriate will be later as 3 months. The award is sum of ₹28,500. Once again, 6%. The next one. Yeah, 413 days in filing the application or 1%. ನಿಮ್ದು ಅಪೀಲ್ ಇದೆಯಾ? ಎಷ್ಟು ತಗೊಂಡಿದ್ರಿ ಇನ್ಕಮ್? 7 years. ಹೋಗ್ಬೇಕಲ್ವಾ? ಇದಾದ್ಮೇಲೆ ತಗೋಬೇಕು ಅಂತ ಇದೆ ಅಲ್ಲ. ಎಷ್ಟು ಇನ್ಕಮ್ ಎಷ್ಟು? %40 ಸೇರಿಸ್ಬೇಕಲ್ವಾ? minus 50%. ಯಾರು ಕ್ಲೇಮೆಂಟ್ಸ್ ಯಾರು? In respect of an accident which is not in dispute and which resulted in the death of someone, an 18-year-old, the tribunal has awarded the following sums. 17 years. 17 years. The tribunal has awarded a lump sum of rupees 4,80,000. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 30,000 ತಗೊಂಡಿದ್ದಾರಾ? Tribunal has taken the notional income of rupees 30,000 per month and has awarded some of rupees 4,80,000. The right of judgment rendered by this court in MFA 1022 68 per 2019. The compensation had to be awarded by adopting the multiplier method and by applying the gross income fixed by KSLS. Consequently, claimant being the deceased being 17 years old, the sum of rupees 9,500 fixed is income by KSLS maximum year 2016. The claimants invented from rupees 9,000 to the said sum 40% would have been added towards future prospects, and consequently, claimant went into the following sum towards cost of dependency. The claimants being the parents who entitled to sum of 44,000 each, totaling 33,000. 6%. Excluded. Excluded. Who's R7? Favor application carried out in respect of R7 is accepted. R7 called out, is absent and displaced expert. Next week. The question notice to R1 and R4 is dispensed with. Who's R3? ಹೆಸರು ಹೇಳಿದ್ರೆ ಬರ್ದ್ಬಿಡ್ತೀನಿ. ಪ್ಲೀಸ್ ನೋಡ್ಕೊಂಡು ಬರ್ಬಿಡಿ ಯಾರು ಯಾರಿದ್ದಾರೆ ಈ ಅಪ್ಪೀಲಲ್ಲಿ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಬರ್ಬೋದು ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಅವ್ರು give it in a slip of paper, you'll write it. ರಿಕವರಿ ಮಾಡ್ತೀನಿ. ಅದೇ ಕಾನೂನು ತಗೊಳ್ಳಿ ಹಂಗಾರೆ. Which time is granted? Take out notice on R1. As requested notice to R1 is dispensed with. Delay of 410 days. According to police conduct, no interest. Post along with them. ಯಾರು R1 ಯಾರು?
R1 is a owner, my lord. The 163A, my lord. R1 is a owner. ಏನು ಬೇಕಾಗಿಲ್ಲ. ಲಾರ್ಡ್ಶಿಪ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ ದೇರ್, my lord. 163A. In this case, my lord, the deceased, my lord, died, my lord, his kit and my lord, Paul, my lord. So, the case of death, my lord, the income was taken rightly, my lord, and awarded 4 lakh something, my lord.
ಅಪೀಲ್ ಏನಕ್ಕೆ ಹಾಕಿದಾರ?
ಅಪೀಲ್ ಎನೌನ್ಸ್ಮೆಂಟ್ ಗೆ ಅಂತ ಆಗ್ತದೆ ಅಲ್ಲ?
ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೊಡಕ್ಕೆ?
ಇಲ್ಲ ಏನಿಲ್ಲ, ಅದು 40,000 ಇನ್ಕಮ್ ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡಿದ್ದಾರೆ. ಫ್ಯೂನರಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 2,500 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಮಾರ್ಜಿನಲ್ ಅನೌನ್ಸ್ಮೆಂಟ್.
ನಿಮ್ಮ ಅಪೀಲ್ ಏನು? ಕವರ್ ಆಗಲ್ಲ.
ಈ ವಿಳಾಸದಾರರು ಬಟವಾಡೆ ವೇಳೆಯಲ್ಲಿ ಸಿಕ್ಕದ ಕಾರಣ
ಮಾಡಿಸ್ಬಿಡಿ ಶ್ರೀನಿವಾಸನ್ ಅವ್ರಿಗೆ, ಸರ್ವ್ ಮಾಡಿಸ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಓನರ್ಗೆ
ಪ್ಲೀಸ್.
ಬಿಗ್ ಸ್ಟ್ಯಾಂಡ್. ಆಪರೇಷನ್ಸ್ ಎಲ್ಲ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮ್ ಮಾಡ್ಲಿಲ್ವಾ? ಹೆಡ್ ಇಂಜುರಿ ಅವ್ನಿಗೇನ್ ಆಗಿಲ್ವಾ? ಬಟ್ ಅವ್ನಿಗೇನಿದೆ ಲಾಸ್ಟಿಂಗ್ ಎಫೆಕ್ಟ್ ಇದ್ರದ್ದು ಇಂಜುರಿ ಇದೆ. ಏನಾಗಿದೆ? ಎಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ ಯಾರು ಡಾಕ್ಟ್ರು? ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಇದೆಯಾ? ಆಯ್ತು, 2 days ಕೊಡೋಣ, ಇದ್ರದ್ದು ಹೇಳಿ. ಏನಾದ್ರು ಹೇಳ್ಬೇಕಲ್ವಾ? ಸುಮ್ಮನೆ ನಾನು 100% ಡಿಸಬಿಲಿಟಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದ, ಏನ್ ಕೆಲಸ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅಮ್ಯುನಿಟೀಸ್ ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಮಾರ್ಜಿನಲ್ ಡಿಸಬಿಲಿಟಿ ಇಲ್ಲ, ಡಿಸಬಿಲಿಟಿ ಇದ್ದರೆ ಹೇಳಿರೋರು. ಇಲ್ಲ, ಮುಖದಲ್ಲಿ ಡಿಫಾರ್ಮಿಟಿ ಇದೆ, ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ ಬರ್ಬೋದು, ಬಟ್ ಅವನ ಮೆಂಟಲಿ ಹೆಡ್ ಇಂಜುರಿಗೆ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ, ಅದರಿಂದ ಎಫೆಕ್ಟ್ ಏನಾಯ್ತು ಅಂತ. ಹೆಂಗ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿರಿ, ಯಾವ ತರ ಕೊಡ್ಬೇಕು, ಶಾಂತರಾಜ್ ಹೇಳೋರು ಕೊಡ್ಬೇಕು ಅಂತ ಕೊಟ್ಬಿಡ್ತೀನಿ ನಾನು. In respect of an accident which is not in dispute, the tribunal has awarded the following sums. The claimant was admittedly hospitalized for about 50 52 days. And he was in fact hospitalized in Nimmans for 5 days, at Victoria Hospital for 16 days and 17 days. Current counsel for the appellant also files a memo along with the photographs of the claimant, which indicates that there is a severe deformity in the case of the claimant, and one portion of his head has virtually caved in. In the light of the medical evidence on record that he was hospitalized for 52 days, and in light of the photographs that are now produced, in my view, it would be appropriate to award some rupees 75,000 towards pain and suffering, and rupees 75,000 towards loss of amenities. The sum of rupees 13,889 awarded towards medical expenses cannot be found fault with and is affirmed. The tribunal has awarded a sum of rupees 10,000 towards transportation charges and nutrition, apart from rupees 10,400 for attendant charges. So since the claimant was hospitalized for more than 50 days in 3 different in Nimmans and in Victoria, it would be appropriate to award a sum of rupees 50,000 towards conveyance, transportation, conveyance, nutrition, and attendant charges. The tribunal has taken the laid-up period as just 1 month and has awarded rupees 6,000. As stated above, the claimant was admitted for more than 52 days. Therefore, we appropriate to determine the laid-up period as 6 months and award a sum of rupees 6,500. 6,000 into 12. Consequently, the interest, no interest, no interest. Or then appeal, no?
Serial 13.
13 next week.
Next week.
And then appeal the value. Liability can ground. Charge sheet. Driver ಏನ್ ಹೇಳ್ತಾನೆ? ಸುತ್ತಲ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು ಚಲ್ವಾ that is after the accident. Now, after the accident, you will definitely pull over to the left side. You can't block the traffic. That's why you pull over. Road was under repair, huh? Then how can he be traveling in a rash and negligent manner in a road which is being repaired? Mud road ಅದು. ಏನಾದ್ರು ಜೋರಾಗ ಆದ್ರೆ ಪುರಿ ಬಸ್ಸಲ್ಲಿ ಹೋಗಕ್ಕಾಗದಲ್ಲಿ. If at all, if anybody can go fast on a mud road, it can only be the bus, not the two-wheeler. Then ಕಮ್ಮಿ ಏನಾಗಿದೆ? $7,000, 25%. Claimants ಯಾರಂದ್ರೆ? -1/3. Who's the claimants? In respect of an accident which is not in dispute, the tribunal has awarded the following sums. The KSRTC as well as the claimants are in appeal. The KSRTC contends that the attribution of negligence on its driver was incorrect. The claimants however contend that the tribunal has correctly attributed negligence to the driver of the KSRTC bus, and they also contend that the amounts awarded are on the lower side. It is not in dispute that the charge sheet was laid against the driver of the bus. The evidence on record indicates that the road work was going on and the entire road was under repairs and it was essentially a mud road. The driver, who was examined as RW1, admits that he saw the deceased riding the motorcycle in a rash and negligent manner. Thus, he thereby admits that he had a clear line of vision and was able to see the driver. Having regard to the fact that the road was under repairs and was essentially a mud road, it was obviously easy for the driver of the bus to have avoided the accident. However, the fact that the IME report indicates that there was damage to the right-hand side bumper of the bus indicates that the negligence was on the part of the driver of the bus. The fact that the police have also laid a charge sheet against the driver points to the fact that the driver of the bus was negligent. So there is therefore no grounds made out to interfere with the award of the tribunal on the ground of negligence, and the appeal of the case is therefore dismissed. As far as compensation is concerned, the tribunal has taken the income at rupees 10,000. However, since KSLSC has fixed the amount of rupees 11,000 for an accident of the year 2017, the same will have to be adopted. As the deceased was aged 44 years, 45 years, 41 years. 25% will be added towards future prospects, which will result in the monthly income to his source. Out of this, 1/3 will be deducted towards his personal expenditure, and consequently, the payment will be made in the source. The claimants being the wife and children, each of them will be entitled to 44,000, apart from 33,000. 6%. 6%. Take on. Is there a delay? There is delay control. 200 days. 365 male adre matter. Insurance company bedva? Insurance company. PB Raju take notice for R2. The normal liability diya. Why were they exonerated? Why were they exonerated? Insurance company. Or madidara. Liability diya. EVR ge. In ground ena. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಎಂಪ್ಲಾಯರ್ ಎಷ್ಟು ಹೇಳಿದ್ರು?
9,000.
What was he driving? Driver? Driver of? $6,129 ತಗೊಂಡಿದ್ದಾರಾ? 129. 50% ಡಿಡಕ್ಟ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ. Whether the tribunal was justified in coming to the conclusion that the wage of the deceased should be construed as rupees 6,129.90. That is the minimum wage is prescribed for the period 1/4/2015 to 31/3/2016. Is a question of substantial question involved in this appeal. It is no doubt true. The trial court has assessed the monthly income of the deceased on the basis of the notification prescribed under the Minimum Wages Act, which indicated that the minimum wage that a driver should be paid as on 6/3/2016 was rupees 6,129. Merely because a minimum wage is prescribed, it cannot be assumed that that would be the wages. It's to be noticed here that the minimum wages prescribed is the basic minimum which is required to be paid by the employer and does not actually reflect the wages that an employee would earn. In that view of the matter, the application of the minimum wages as the wages of the deceased would be incorrect. The question of law is accordingly answered in favor of the claimants. The KSLSA in respect of action year 2016 has fixed rupees 9,500 as the notional income. In my view, it would be appropriate to adopt the said income as the income of the deceased. 50% of this, that is rupees 4,750, will have to be taken for the purpose of calculating the loss of dependency and is required to be multiplied with the relevant factor. Consequently, the claimant will entitle rupees so and so as compensation. The appeal is thus allowed in part. Interest at the rate of 12% shall be paid from the date of expiry of 1 month from the date of the accident. Policyಯಲ್ಲಿ ಅವ್ರದ್ದೇನು interest penalty ಅವ್ರು ಕೊಡ್ಬೇಕು, ಯಾರು ಕೊಡ್ಬೇಕು? You have a copy of the policy with you?
I appear for the appellant. It's only questioning quantum.
ಜಾಸ್ತಿ ಆಗಿದೆಯಾ?
ಹೌದು, ಇದು damages to the car ಮೇಲೆ. car 386 of 2017 case number. It starts from page 18 of the judgment. Relevant para is at 27. ಅದೇ ಫಸ್ಟ್ ಇಂಜುರಿ ಇದ್ ಮಾಡ್ತಾರೆ, ಡಾಕ್ಟರ್ ನೇನ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರ ಬಗ್ಗೆ ಪ್ಯಾರಾ 27 ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಅವರು ಯಾರನ್ನೂ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಆನ್ ದ ಕಾಂಟ್ರರಿ, ನಾವು ವಿ ಹ್ಯಾವ್ ಎಕ್ಸಾಮಿನ್ಡ್ ಅವರ್ ಆಫೀಸರ್ ಮೇಲೆ.
ಎಕ್ಸಿಬಿಟ್ P14
P14 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅವರು, ಬಟ್ ಯಾರನ್ನೂ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅವರು.
ಅದು ಯಾರು P14 is by an authorized ಸರ್ವಿಸ್ ಸೆಂಟರ್ ಅಂತಲ್ಲ ಮೇಡಮ್ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಅದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅವರು, ಬರೀ ಇದನ್ನ ಮಾತ್ರ ಹಾಕ್ತಾರೆ ಅಷ್ಟೇನೆ. ಅದು 2005 ಮಾಡೆಲ್ ಕಾರ್, ಅದು 10-year old ಇದು. ಅದ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ಗೆ ನಿಲ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇವಾಗ.
Authorized Maruti service center, madam, idu. It's not by some private person. Authorized. ಅಲ್ವಾ?
ಆಮೇಲೆ ಅವರು 1,20,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರದ್ದು ಕಾರ್ದು ಇದೇನೆ ಅವ್ರ 55 ನಮ್ಮವ್ರದ್ದು ಒಂದು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೇವೆ. ಅದನ್ನೊಂಚೂರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬಿಡ್ಲಿ.
ಏನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಾರ?
ನಾವು ಆ ಮಾಡೆಲ್ ಕಾರ್ಗೆ ಎಷ್ಟು ಇದಿದೆ, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. RW1 ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ವಿ. ನ್ಯೂ ಆಲ್ಟೋ ಕಾರೇ 2,80,000ದಿಂದ 3,00,000 ಇದೆ. Since it is a 10-year old car, ಅದರದ್ದು 55,000 ಅಷ್ಟೇ ಅದರದ್ದು ವ್ಯಾಲ್ಯೂ ಇರೋದು ಅಂತ.
ಯಾವ್ದ್ರದ್ದು? ಕಾರ್ದು
2005 model car, Milan. Accident is in 2015.
But I was under the impression if an accident occurs and the owner of the car says, no, I will get it repaired, you can't refuse repairs. You can't say the value of the car is 30,000, repair is 60,000, therefore I will not pay you. It is his choice to get it repaired or not. Can you say that no, sell it off because it's not worth it? Because you would have to pay 1.5 lakhs.
At least ಅವ್ರು ಏನ್ ಡ್ಯಾಮೇಜಸ್ ಆಗಿದೆ, ಅವ್ರು ಏನ್ ಅದನ್ನ ಇದ್ ಮಾಡಿದ್ದಾರೆ, ಯಾವ್ದೇ ಅದಕ್ಕೆ ಅವರು ಅಷ್ಟೊಂದು ದುಡ್ಡು ಹಾಕಿದ್ದಾರೆ ಅಂತನಾದ್ರೂ ಹೇಳಿಸ್ಬೇಕಲ್ವಾ ಸ್ವಾಮಿ. ಸುಮ್ನೆ ಆಥರೈಸ್
ಕೊಟ್ಟಿದಾರಲ್ಲ, ಬಿಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಥರೈಸ್ ಸರ್ವಿಸ್ ಸೆಂಟರ್ ಬಿಲ್
ಕೊಟ್ಟಿದ್ದಾರೆ. ಡ್ಯಾಮೇಜಸ್ ಏನಿದೆ ಅದಕ್ಕೆ ಸರಿಗಿದೆಯಾ ಅಂತ ಅದನ್ನ ಹೇಳಿಸ್ಬೇಕಲ್ವಾ ಸ್ವಾಮಿ. ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೇಕಲ್ವಾ ಸ್ವಾಮಿ.
ಅಷ್ಟೇನಾ? The insurer is nothing. Challenging the sum of rupees 1,20,000 awarded as compensation for the damages to the car. The tribunal has awarded a sum of rupees 1,10,000 towards the damages incurred and rupees 10,000 towards mental agony. On the basis of the damages that have been assessed at rupees 1,10,000 is on the basis of Exhibit P14. Exhibit P14 is the bill, is the receipt for having paid a sum of rupees 1,10,000 to Bharat Auto Cars Private Limited. Exhibit P15 is the bill issued in respect of the repairs carried out on the car in question by Bharat Auto Cars Private Limited. It is noticed that Bharat Auto Cars is an authorized Maruti Suzuki dealer and service center. Since the vehicle was repaired by an authorized service center, the bill which has been produced has rightly been accepted with the trial court. I find no reason to interfere with the award of the labor court, the trial court, and the appeal is therefore dismissed. Not consequent the appellant contends that the insured declared value was only rupees 55,000 according to the policy, and therefore the award of 1,20,000 was improper. Notwithstanding the fact that the value of the car was declared as 58,000, that cannot lead to an inference that repairing a damaged car cannot exceed the value of the car. This argument is therefore rejected. Next week. Okay. R1, R1 and R3. ಏನಕ್ಕೆ? ಅರ್ಧ. ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್? ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನ್ ಹೇಳ್ತೀರಿ ನೀವು? ನೆಕ್ಸ್ಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು? Both the owner of the vehicle as well as the claimants are on appeal, challenging the award of rupees. ನೀವು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ? ಚಾಲೆಂಜಿಂಗ್ ದಿ award of rupees 24,000. ಎಷ್ಟು ಕೊಟ್ರು? ವಾರ್ಡ್ ಎಷ್ಟು? 7,12,000. 1,12,000. 301. The claimants are in appeal, not only challenging the attribution of 20% contributed negligence, but also on the ground that the sums awarded are on the lower side. The owner of the vehicle, that is respondent number 1 and 3, are also in appeal contending that a greater degree of contributed negligence, also in appeal contending that the deceased alone was responsible for the accident. It is the accident which occurred on 31/8/2016 between the car owned by respondent number 1 and 3 and the deceased is not in dispute. The fact that the death occurred as a result of the accident is also not in dispute. The learned counsel for respondent 1 and 3 contended that the evidence on record indicated that the driver of the deceased himself was responsible for the accident. It may be pertinent to state here that the charge sheet was laid against the driver of the car, thus given according to the police, because the driver of the car was responsible for the accident. Furthermore, there is no evidence adduced by respondent 1 and 3 to indicate that the deceased had contributed to the accident. For the reasons best known to respondent 1 and 3, the driver of the car was not examined, and it was this driver who would have been the best witness to describe the accident and thereby assist the court in coming to a conclusion regarding the negligence. In the absence of any evidence on the part of respondents 1 and 3, and in the light of the fact that the charge sheet had been laid against the driver of the car owned by respondents 1 and 3, the tribunal was not right in attributing 20% negligence to the deceased. I am therefore of the view that the entire negligence for the accident ought to have been apportioned only on the driver of the car. The sketch which is produced as Exhibit P8 also indicates that the accident occurred on the extreme left-hand side of the road, and the car had in fact come onto the opposite side of the road. This also affirms the fact that the driver of the car was responsible for the accident. The appeal of the respondent 1 and 3 regarding negligence is therefore dismissed, and the appeal of the claimants as regards negligence is allowed, and it is held that the driver of the case of the car was alone responsible for the accident. As far as compensation is concerned, the tribunal has determined the notional income at rupees 9,000. So since the accidents of the year 2016, the sum of rupees 9,500 fixed by case solicitor to be applied. As the deceased was aged 47 years, 25% would have to be added towards future prospects, which would result in the income to rupees so on. Consequently, towards loss of dependency, the claimants will be entitled to rupees so on. The tribunal has awarded some of these 1,06,301 towards medical expenses. This award being based on document evidence will have to be affirmed. The claimants being the wife and children, wife and daughter, each of them would be entitled to some rupees 44,000 towards loss of love and affection, apart from some rupees 33,000 under the conventional acts. Consequently, the claimants will be entitled to so respondents 1 to 3 shall deposit the said compensation within a period of 2 months. ಏನಕ್ಕೆ ಆಕ್ಚುಲಿ ನೀವು ಕಾಸು ಕೊಟ್ಬಿಡ್ಬೇಕಿತ್ತು, ನೀವು ಅಪೀಲ್ ಹಾಕ್ಬಾರ್ದಾಗಿತ್ತು ಅಲ್ವಾ? ಒಬ್ಬನ ಜೀವ ತಗೊಂಡ್ಬಿಟ್ಟು ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ಲ, ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕಿತ್ತಾನೆ. R3 R1 and 3 ಅಂದ್ರೆ R2 KGAD, R1 and R3 ತಾನೆ. R1 and R3 ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಇದೇನು 18.2 ಏನೋ ಜುರಿ ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ? The owner of the car has also filed an appeal against the sum of rupees 24,000 awarded for the injuries suffered by the claimant. In my view, having regard to the evidence on record, the sum of rupees 30,000 awarded. 30,000 alva.
Negligence 20% reduction.
Sum of rupees 30,000 and deducted 20% of the said amount as contributor negligence. In view of the fact that the attribution of contributor negligence on the deceased has been set aside, the reduction of compensation to the extent of 20% cannot be sustained, and the same is also accordingly set aside. The tribunal has awarded some rupees 30,000 towards pain and suffering and towards conveyance, nourishment and nutrition. In my view, this compensation awarded is just and proper, and therefore they have to be affirmed. If that finding regarding contributing negligence goes, what will happen? There one appeal I am affirming and one appeal I am saying they don't have to. Order 4133 I have the power. So then it comes for the respondent number 1 and 3 contents, that since claimants have not filed any appeal seeking for enhancement or challenging the finding regarding negligence, the removal of contributing negligence on them would be incorrect. This is stated here that the appellate court has been conferred with the power under order 4143 to pass such orders as the trial court ought to have passed. So since in the connected matter, the finding regarding contributor negligence has been set aside, it would be imperative that the said finding also be set aside in this appeal in excess of the power under order 4133, though no appeal or cross objection is filed with the claimants. I will Rangegowda to take notice for 1 ನೀವು R1. Who was driving the two-wheeler?
Early may not be examined, the police had furnished the driving license. And producing that driving license, we examined the article. He stated that it is not valid, not accept that. I come to the conclusion that we have not proved that.
Even if you prove that he had no license, can recover it. Or appeal hakidara. In case of injury, case of injury. Since in the companion appeal, R2 has been served, notice to me is insufficient. The tribunal, in respect of an undisputed accident, has awarded the following sums. So both the insurer as well as the claimant are in appeal. So the insurer contends that the driver of the car that it had insured did not establish that he was the driving license. It is also stated that the insurer took steps to summon the owner and also the investigating officer. Yet the tribunal has recorded a finding that the insurer had been unable to prove that the driver of the owner cum driver of the insured car did not possess a driving license. In my view, since it is the contention of the insurer that the driver of the insured car did not possess a driving license, it would still nevertheless have to pay the compensation and thereafter proceed to recover the same from the owner of the offending vehicle. Thus, to this extent, the finding of the tribunal will have to be modified and the insurer will be directed to deposit the compensation and thereafter proceed to recover the same from the owner of the offending vehicle. As far as compensation is concerned, the evidence on record indicates that the petitioner had a crush injury to his right hand and also suffered injuries to his right ankle. Doctor examine madra? Is there disability? To the limb and page 20 na. ಇಲ್ಲಿಂದ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ವಾ? 45% ಅಂತಾರೆ ಇವರು. He has lost hence patient not able to move right shoulder, right elbow, and complete loss of right hand functions and complete loss of muscle power in the right shoulder, right elbow, and right wrist with loss of sensation in the right upper limb. Hence 90% of the function of the right upper limb is completely lost and the total body permanent disability is 45%. Discharge summary ಎಲ್ಲಿದೆ? He is a treated doctor. No, but you want to see the evidence of the doctor? Reasoning ಅಲ್ಲ, evidence ನೋಡಿ. ಇಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? Page 14. No, but he has said he has lost the complete use of his right hand. He is unable to move his shoulder, no sensation. No, but he said, I'm sure he was present in the court below. And you have cross-ex.
For his age, cannot be. But 90% ಅಲ್ಲಿ 1/3 ಇನ್ನೊಂದು 10% ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
Madam,
10%, 30% ಆಗುತ್ತೆ.
shoulder purti in the, if you can't move at all, then what is it dedicated to? That means you're doubting the word of the.
90%
You could have subjected himself. You could have subjected himself to to another medical examination there. So if I keep the appeal pending for 10 years, then no compensation. The doctor who was examined has stated that the claimant did not have a neurological recovery of the brachial plexus injury, and he was not able to move his right shoulder, right elbow, and had lost complete functioning of the right hand. He has also stated that the claimant had complete loss of muscle power in the right shoulder, right elbow, and right wrist, coupled with a loss of sensation in the right upper limb. He has therefore stated that the claimant had 90% function, 90% disability to the right upper limb, and he has assessed the total body disability at 45%. In my view, if a 37-year-old has suffered the loss of the entire right upper limb, it would be appropriate to determine the loss of total body disability at 45% and also functional disability at 45%. Since the accident is of the year 2000, evidence ಏನಿಲ್ಲ 2017, and there is no evidence to establish the actual income. The claimant will be appropriate to determine the house income at rupees 11,000. Since the claimant has suffered 45% disability, 40% future prospects would have to be added to result in a monthly income of rupees so and so. Consequently, towards loss of future income, the claimant may get this rupees so and so. The tribunal has awarded a sum of rupees 60,000 towards pain and suffering. So in my view, since the claimant has lost his use of the right upper limb, it would be appropriate to award a sum of rupees 1 lakh towards pain and suffering. Similarly, the amount of rupees 20,000 awarded towards loss of amenities will have to be enhanced rupees 1 lakh. The sum of rupees 34,182 awarded towards as medical expenses, and the sum of rupees 20,000 awarded towards attendant conveyance, food and return charges are affirmed. Since the income is now treated as 11,000, the payment went into sum of rupees 33,000 towards loss of income in the later period. Consequently, family went 6%. Telecast. ಮಹೇಶ್ ಅವರೇ,
ಶಿವ ಮಹೇಶ್,
ಅವ್ರದ್ದೇನು ಅಪೀಲು? ತಗೊಳ್ಳಿ ಅವ್ರೆ ನಿಮ್ಮ ಅಪೀಲು. ಹೋಗ್ತಾರೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಮೇಲೆ ಅಪೀಲು. ಹರ್ಷಿತ್ ನಿಮ್ಮಲ್ಲಿ ತಾನೆ? $20 ಡಾಕ್ಟರ್.
As a data person, the driver, salary certificate also produced 18,000 per month salary. Salary, please, salary certificate. 18,000.
What is exhibit P7? Any bank passbook produced to show? Their employer yaru?
Driving license also produced through the agreed to 30.
ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರೆ 15,000 ರೂಪಾಯಿ ವೇತನ ಅಂತ. ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಆತನಿಗೆ ತಿಂಗಳಿಗೆ 15,000 ರೂಪಾಯಿ ವೇತನ ಹಾಗೂ ದಿನಕ್ಕೆ 100 ರೂಪಾಯಿಗಳ ಪಾಠ ನೀಡುತ್ತಿದೆ ಎಂದರೆ ಸುಳ್ಳು ನುಡುತ್ತಿದ್ದೇನೆ. Your suggestion is 15,000. ಇಲ್ಲ ಸಜೆಷನ್ ಇಸ್ 15,000 ರೂಪಾಯಿ 100 ರೂಪಾಯಿ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ ನೀವು ಅಂತ. P7 ಏನ್ ಲೈಸೆನ್ಸ್ ಇದ್ದಿದ್ದು ಅವನಿಗೆ? P0. ₹15,000 ತಗೊಳ್ತೀನಿ. ಅಲ್ಲ ನಿಮ್ KSRTC ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಬಸ್ ಡ್ರೈವರ್ಗೆ? ಅಲ್ಲ ಎಷ್ಟು ಕೊಡ್ತೀರಾ? ಯಾಕಂದ್ರೆ ಇದು ಲಾರಿ ಡ್ರೈವರ್ ತಾನೆ. No, for him to have secured a transport license and a passenger service vehicle license by itself indicates that he is a professional driver. Accident ಆದ ಕೆಲಸ ಮಾಡ್ತಿದ್ದ ಅವನು ಲಾರಿ ಓಡಿಸ್ತಾ. If he can own a motorcycle, that means he can earn 50,000. No. In respect of not in dispute, the tribunal has awarded the following. The KSRTC as well as the claimants are on appeal. It is the contention of the KSRTC that the accident occurred only because of the negligence on the part of the claimant. The claimant, on the other hand, contends that the action occurred because of the negligence of the KSRTC. He also contends that the sums awarded by the tribunal were on the lower side. In this case, it is not in dispute that the charge sheet was laid against the driver of the KSRTC bus, and this by itself points to the fact that he was responsible for the accident. The tribunal, on an analysis of the evidence, has correctly come to the conclusion that the accident occurred only because of the negligence on the part of the driver of the KSRTC bus. I find no reason to disturb the said finding. As regards compensation, the tribunal has assessed the income notionally at rupees 8,000 and has assessed the disability at 12%, 15% of the whole body. As per the tribunal, %20 disability whole body ಹೇಳಿಲ್ವಾ? Yeah, 60% disability left leg and 20% of the whole body. Grade 3 compound comminuted fracture, lower third left femur. Left. ಇಲ್ಲ ಇಲ್ಲಿ
wrong ಮಾಡಿದೆ.
ರೈಟ್ ಫೀಮರ್ ಅಂತಾನೆ ಅದು. ರೈಟ್ ಫೀಮರ್ ಲೆಫ್ಟ್ ಫೀಮರ್ ಡಿಫರೆನ್ಸ್ ಆಗುತ್ತಾ ಇಂಜುರಿಯಲ್ಲಿ? But the medical record also confirms it is right femur. Right leg ಆಗಿರೋದು. The doctor was examined as PW2 as stated. The claimant has suffered a total disability of 20% to the left leg. Learned counsel for the KSRTC contends that the medical evidence produced by itself indicates that the claimant had suffered a fracture to the right leg, and this would therefore indicate that the evidence of the doctor cannot be relied upon. It is no doubt true that the doctor has stated that the claimant has suffered a disability of 60% to the left leg and 20% to the whole body. However, the evidence record, medical evidence on record indicates that the claimant had actually suffered a fracture of the femur of his right leg and not the left leg. It is to be noticed here that the fact that the claimant suffered a fracture to the femur is not in dispute, and there is no doubt a mistake in the evidence of the doctor in stating that he had suffered a disability to the left leg. Since the evidence on record indicates that the claimant had indeed suffered a fracture to the right leg, the percentage of disability assessed by the doctor cannot be found fault. The evidence as regards the income is concerned, the tribunal has taken the most income at rupees 8,000. And also the claimant contends that he had examined the employer who stated that he was paying a sum of rupees 18,000. However, there is no evidence indicating that the claimant was being paid 18,000 rupees through the bank. It will therefore be difficult to accept that he was being paid some rupees 18,000. However, I am in regard to the fact that the claimant was holding a driving license to drive a transport vehicle and also a passenger service vehicle, it would be appropriate to determine the monthly income at rupees 15,000. Since the claimant has about 20% disability, 40% be added towards future prospects, it will result in the monthly income to rupees 7. Consequently, the claimant will maintain to rupees 7. The tribunal has awarded some rupees 24,000 towards pain and suffering and rupees 15,000 towards amenities. In my view, it is appropriate to enhance assets of rupees 50,000 and 30,000. The tribunal has awarded some rupees 3,10,514 towards medical expenses and some rupees 20,000 towards future medical expenses. These sums are just and proper and are therefore affirmed. The tribunal is awarded a sum of rupees 30,000 towards food and nourishment and attendant charges. The evidence on record indicates the payment was hospitalized for 86 days. In my view, it would be appropriate to award a sum of rupees 70,000 towards food nourishment, conveyance and attendant charges. The tribunal has taken the later period as 3 months. Since the claimant was hospitalized for almost 3 months, it is appropriate to treat the later period as 90 days, 6 months, and award a sum of rupees 15,000 90,000 rupees towards loss from the later period. Consequently, it was allowed in. Okay, other than Henry. ಇದೆ. That is not with removal of implements, taking into consideration nature of fracture and injury sustained. General for the movies 20,000 towards future. ಅಲ್ಲ ಇದು ಇಂಪ್ಲಾಂಟ್ಸ್ ರಿಮೂವಲ್ ಅಲ್ಲ. Having regard to the nature of injuries, 20,000 ರೂಪಾಯಿ ಬೇಕಾಗುತ್ತೆ ಅವ್ನಿಗೆ ಅಂತ ಕೊಟ್ಟಿರೋದು. Correct? Not for removal of implants. ಮಾಡ್ತಾರೆ. ಮಹೇಶ್ ಅವರೇ, ಅವ್ರದ್ದೇನ ಅಪೀಲ್? ಅವ್ರ ಅಪೀಲ್ ಏನು?
ಯುವ ಮಹೇಶ್,
ಮಹೇಶ್ ಅವರೇ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀನಿ, ಬರ್ಲಿ ಅವ್ರು ಕೊಡ್ತಾರೆ. ಓದಿದ್ರಿಗೆ ಅವ್ರು ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ತೀನಿ ಹೇಳಿ. ಇದನ್ನ ಅವ್ರ ಮೇಲೆ ಮಾಡಕ್ ಆಗಲ್ಲ.
This is a policy which is nature of one. We have proved that the owner has proved that Yunus is the agent that has the policy, but the insurance company has not disputed that he is not the agent of the insurance company, but they have not initiated any action against the agent, and also the owner for producing such fake policy never insurance. No, the owner of the vessel with the insurance company.
Where do they admit that there was issuance of a policy by the agent?
Paragraph number 25 of the judgment.
Mahesh ಅವರೇ,
RW1 is the insurance company officer. Paragraph number 25. You will start from paragraph number 24. Letter counsel for the petition number 1 confronted exhibit R3, paragraph number 25 amendment. Policy same is submitted by RW1 in cross-examination. According to said judgment, agent code number is so and so. The fact is categorically denied by RW1. Further, RW1 stated that they have not taken action against concerned person who are created fake insurance policy. The learned counsel for petition create number of cases of the other source have taken serious steps against fake insurance policy created is a great negligence on part of the insurance company. It is founded duty of the requirement number 2. Insurance company to take some serious steps against the insurance policy created. Plus, their own agent has taken the policy.
but you admit that Yunus said, don't give a complaint against me, I will pay you 15,000 or 20,000. That means he admits that there was no policy. Why would Yunus agree to pay 15,000, 20,000?
He has paid the premium to Yunus.
So therefore, they have not issued the policy.
So it is their agent, my lord, the agent has created the policy.
Where do they admit that they had issued that? How can you make them liable for that? No, they categorically state that the policy number that was given was related to a different motorcycle number. They can't be held responsible for some fraud that is being played by some agent. You should have paid by way of a check if you wanted to be a bit careful. Owner ಮೇಲೆ ಹೋಗಿ ಹೆಂಗಾಗುತ್ತೆ ಇನ್ಶೂರೆನ್ಸ್ ಇದ್ದು ಬ್ರೀಚ್ ಆಫ್ ಪಾಲಿಸಿ ಕಂಡೀಷನಲ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ. If somebody plays fraud against the insurer, you can't say that they are responsible. ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ. The owner, the claimant is in appeal, challenging the award of rupees 31 lakhs, 31,71,958 awarded as compensation for the death of Dhananjayappa, a 58-year-old. The tribunal has exonerated the liability of the insurer on the ground that the insurer had not issued the policy in question, and the policy which was produced before the tribunal was a fake policy. It is not in dispute that a policy was produced is not in dispute. Policy was before the tribunal having a policy number 10010-31-13-003389. Shri Abhinandan, the legal officer, was examined as RW1. In his evidence, as clearly stated that this policy was issued in the name of one Ravi RP to cover the motorcycle bearing number KA54H0596 and was valid from 99-2012 to 89-2013. He has also stated that the insurance company has not issued any policy to cover the passenger auto rickshaw bearing number KA28-6837. In my view, since the policy which was relied upon by the claimants does not relate to the auto rickshaw in question, the insurer cannot be made liable for the compensation. It may also be pertinent to state here that the owner of the auto rickshaw was examined, and he has deposed that one Yunus had issued him this policy, and when he questioned him, he had requested the owner not to lodge a complaint and that he would pay 15,000-20,000 rupees. In my view, this evidence also confirms the fact that the vehicle in question was not insured, and the policy number furnished was not relatable to the auto rickshaw. And therefore of the view that the exoneration of liability of the insurer, that is the second respondent, cannot be found forthwith. The appeal insofar as liability is concerned is therefore dismissed. As far as compensation is concerned, it is noticed that the sums awarded with the tribunal is just and proper and does not require any enhancement. Consequently, the appeal is dismissed.
Right. Climate's appeal. Time period dismissal.
Idara Venkatesh idara?
Idin Somi. My claim petition dismissal. Attributing entire negligence disease motorcycle rider. His collision between lorry and motorcycle, my lord. Initially, the first information report was lodged against the lorry driver. The charge sheet was laid against the deceased motorcycle rider. That action took place on night, and the lorry which was going ahead of the motorcycle all of a sudden applied brake and reduced the speed without giving any sort of signal to the vehicles following it. In that process, the inevitable accident.
ಯಾವ ತರ ಪಾಲಿಸಿ ಇದು?
ಇಲ್ಲ ಇದು ಥರ್ಡ್ ಅಲ್ಲ ನಮ್ದು ಲಾರಿ ಡ್ರೈವರ್ ಅಪೆಂಡಿಂಗ್ ವೆಹಿಕಲ್ ಇಸ್ ಲಾರಿ ಡ್ರೈವರ್.
ಇಲ್ಲ ನಿಮ್ ಪಾಲಿಸಿ ಯಾವುದು?
ನಮ್ಮದು
they have not made party the
ಅವನೇ ಓನರ್.
Party, he himself is the insured, my lord, owner of the two-wheeler. They have not made party.
FIR is against lorry driver initially. Thereafter, lorry driver was not examined, and he was the only person who witnessed the accident. He was not examined, and action took place night 7:45 p.m.
FIR may kindly be looked into, my lord, including charge sheet.
ಯಾರು ಕೊಟ್ಟಿದ್ದ FIR? ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ಟಿದ್ದ?
ಅಪ್ಪ ಸತ್ತೋದವನ ಅಪ್ಪ ಕೃಷ್ಣಪ್ಪ ಅಂತ ಸ್ವಾಮಿ.
ಅವ್ರಿಗೇನು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ವಲ್ಲ?
ಅವ್ರೇನು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ.
ಯಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, ಯಾರು ಪಿಲ್ ರೈಡರ್ ಇದೆ, ಸ್ವಲ್ಪ ಪಿಲ್ ರೈಡರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಪಿಲ್ ರೈಡರ್ ಇರಲಿಲ್ಲ.
My lord, come to page number 2, my lord, of the judgment of the MEACT.
ಪಿಲ್ ರೈಡರ್ ಇಲ್ಲ ಬಿಡಿ ಸರ್.
That on 22/11/15, deceased Harisha was going towards his native place Vakatagrahara by riding a Activa Honda, so and so, along with Pillin rider by name Kempalingaya. Is not me. It is the MEACT honorable court.
FIR ಎಲ್ಲೂ ಬಂದಿಲ್ಲ, ಇದರಲ್ಲೂ ಬಂದಿಲ್ಲ.
ಬಟ್ ನಿಮ್ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಹೇಳಿದಿರಲ್ಲ ನೀವು.
Yes, ma'am.
ಏನ್ ಗೋಪಾಲ್ ಕೃಷ್ಣ ಅವ್ರು ಏನ್ ಮಾಡೋದು?
My lord, they withheld the very important witness, the driver of the lorry.
You also withheld the pillion rider.
Yes, my lord.
Then, and charge sheet is against you.
Of course, my lord, but FIR is against the driver.
Investigation ಮೇಲೆ charge sheet ಅವ್ರ ಮೇಲೆ ತಾನೆ. PA ಕವರ್ ಏನು ಇರ್ಲಿಲ್ವಾ?
ಏನಿಲ್ಲ, ರಿಮೈಂಡ್ ಮಾಡಿ ಎಕ್ಸಾಮಿನ್ ದಿ ಐ ವಿಟ್ನೆಸ್.
This appeal is filed challenging the dismissal of the claim petition. Third counsel for the appellant submits that the claim petition is dismissed solely on the ground that the charge sheet had been laid against the deceased. He submits that though there was a pillion rider by name Kempalingaya, he therefore prays that the matter may be remanded so that we could examine Kempalingaya. This appeal arises out of dismissal of the claim petition which had been filed seeking for compensation for the death of one Harish, a 24-year-old. The claim petition indicates that Harish was going towards his native village by riding his Honda Activa along with a pillion rider. In my view, since it is a question of negligence, it would be appropriate to remind the matter to the trial court, reserving liberty to the claimants to examine Kemplingaya
Or any other eyewitness.
and also to the claimants to adduce the evidence of any other eyewitness who had witnessed the accident. The impugn order is therefore suggested in the matters remanded to the tribunal, direction tribunal to permit the claimants to adduce the evidence of the pillion ride and also any other witness that may so desire. Since the parties are present, they shall appear before the tribunal on so and so.
My lord, one submission. Idu claimant, the deceased himself being the tortfeasor, Honorable Supreme Court full bench decision, Nishan Singh versus Oriental Insurance Company ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ಒಂದು ವೇಳೆ ಇವನೇ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಗಿ ಇವನ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಇದ್ರೆ ಅವನಿಗೆ 140 ನಲ್ಲಿ ಮಟ್ಟಿಗೆ 150,000 ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ACJ 2018
ನೆಗ್ಲಿಜೆನ್ಸ್ ಮಾಡ್ಲಿ, ನೆಗ್ಲಿಜೆನ್ಸ್ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ ಇರ್ರಿ ಅವ್ರು.
ಸರಿ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಈ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ನನಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರುದಿಲ್ಲ if they succeed my lord, because they have not adduced evidence for the period. For this period I am not liable to pay.
ಗೆಲ್ಬೇಕಲ್ಲ, ನೀವು ಗೆಲ್ಲದೆ ಕಷ್ಟ ಇದೆ, ನೀವು ಆಗ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಹೋಗ್ಬಿಟ್ಟು.
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಹೇಳುದು ಕೋರ್ಟ್ಗೆ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ my lord. ಸರಿ ಸ್ವಾಮಿ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಡೇಟ್ ಯಾವತ್ತು ಬರ್ಬೇಕು ಕೋರ್ಟ್ಗೆ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬಿಟ್ರೆ ನಾನು ಕಂಪನಿಗೆ ತಿಳಿಸಕ್ಕೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
ಡೇಟ್ ಯಾವತ್ತು? ಮೇಲೆ ಹೇಳ್ಬೇಕು. 24th May.
ಸರಿ ಸ್ವಾಮಿ, ಆಯ್ತು. ಒಬ್ಲೈಸ್ ಮೇಲೆ
15,000 ರೂಪಾಯಿ. ಇಲ್ವಾ? ಏನಾಗಿತ್ತು? ಏನ್ ಇಂಜುರಿ ಏನು? ರೈಟ್? ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಮೇಲೆ ಏನಂತ ಹೇಳ್ತಾರೆ? Take it as 11%. 11%. Now, what is the notional income I'll take? Notional income fixed by KSLS I'll take. The claimant being dissatisfied. Even in such cases, we'll take up KSLS being dissatisfied with the compensation of rupees 75,000 awarded as global compensation. The claimant is nothing. The occurrence of the accident is not in dispute, and the fact that the claimant has suffered injury is also not in serious dispute. The doctor who treated the claimant was examined as PW2, and he has stated that the claimant had suffered fracture of both the bones of his right leg. It is also stated that the claimant has suffered 33.6% disability to the right lower limb, and that amounted to 11.2% disability to the whole body. So in my view, in the light of this evidence, it would be appropriate to treat the whole body disability at 11%. Since there is no evidence to assess the actual income of the claimant. The sum of rupees 11,000 fixed by KSLSF fraction of the year 2017 will have to be applied. The claimant being aged 30 years, multiplier of 17 will have to be adopted. Consequently, the claimant maintained sum of rupees 11,000 into 12 into 17 into 11% towards loss of future income. The evidence on record indicates that the claimant had undergone a surgery and was hospitalized for hospital. 3 days. In my view, it would be appropriate to award a sum of rupees 40,000 towards pain and suffering and rupees 20,000 towards loss of immunities. The tribunal has noticed that the claimant had incurred a sum of rupees 61,000 665. It is also noticed that another bill of the same date was also produced for a sum of rupees 21,500. It has thereafter proceeded to award a global compensation of rupees 75,000. In my view, having regard to the bills produced, it would be appropriate to award a sum of rupees 75,000 towards medical expenses. Since the claimant was hospitalized for 3 days, the sum of rupees 5,000 will be also towards conveyance, food and nutrition, and admin charges. Consequently, the claimant will be yes. The other ground have been very the indicated as whether to be permissible.
Ileshwar Das.
Yes.
Say, it's good arrangement. Make use of the treatment. I can understand if the PK order is the content. And we are reaching parties, one is the society, and others are the landowners. If the landowners and the society come, there is some sort of agreement. And it is impractical and illogical. Say that in future only dispute arrangement.
See the GPA one second. So what was the GPA produced?
Produce only the art proceeding by way of filing a memo along with document. But it is not properly stamped, it is an unregistered GPA. Not produced. Your lordship may kindly see the order of the trial court in the order sheet, which is dated 2011-2002. The order sheet, if I may, 2011-2002 order sheet. ಇಪ್ಪತ್ತು 11/2000. The court specifically
Produce ಮಾಡೋದಂಗಿಲ್ಲ ಅಲ್ವಾ? But the specific direction was referred to in para 6 of the plan, and also the original GPA. No. Before they meant the original GPA was directly produced. And this order again of 14th of July 2003 says it was ordered to pay the court fee by 10/12/2012 besides the plaintiff to produce the Supreme Court order referred to in para 6 of the plaint and also produce the declaration and agreement dated so and so. From the order sheet, it is seen that though the matter was adjourned to so and so for complaints, the same has not been complied with. So the original GPA was no. So the original GPA was never produced in the court below. Where is the original GPA? When did he produce it? No, it was never produced with the trial court. When did you file it? Give me the date. I am concerned that the trial court can accept a compromise petition without there being a GPA on record. Please tell me when it was produced, because of the specific order. The order specifically was the proceeding officer doubted this. So therefore he said produce the original of the GPA. So from his order, it indicates that both that relinquishment deed that you're talking about and the original agreement were not produced. And the further order indicates that despite several adjustments granted, it was not produced. So you need to be very sure as to whether you did produce the original GPA or not. This was produced in the RP, this GPA. This K. Bharat Kumar is the paid secretary, correct? This K. Bharat Kumar is a paid secretary, isn't it? Our court said produce the original GP. Yes.
Section 23 and 24 of the Indian Compact Act.
Yes.
Because one of the objects is unlawful if it involves or implies injury to the person or property of another. Because here they want to injure or this way of consent or compromise. They're using court as a tool. It's causing the injury to the property of the appellants. And under section 24, such a contract is void. Such an agreement is void under section 24. Now with these minutes, order 23 rule 3 is repealed. An agreement or compromise in the explanation, if it's void or whatever, shall not be deemed to be lawful within the meaning of this. Because when there is a compromise decree or a void or voidable compromise decree, there are two options first to settle the matter. Earlier we used to file a suit, but under order 23 rule 3 capital A, now filing of a suit is done. The other available option is to approach the very same court by filing an application which we termed as miscellaneous petition and bring it to the notice of dishonorable, notice of the court which recorded a compromise. That's it. The other available option now is
Banwarilal's case. You're relying on that.
rule 1A capital 2.
Yes.
In an appeal against a decree passed in a suit after recording a compromise or refusing to record the compromise, shall be open to the appellant to contest on the ground that the compromise is not other than public. Exactly the read section, that is what Banwari law is. Your Lordship reads para 9 and 14 of Banwari laws.
Continue tomorrow, 2:30.